Sending all of this to Zoom. Okay, it looks like we are live streaming.
Hang on 1 second. You don't have to leave the bench a second.
All right, do you see the live stream at all or not?
Yes, I see live on custom live streaming service. So I'm going to start if that's okay with everyone.
1 second, please.
One moment.
The judge had to leave the bench a second.
Okay.
Look over here. Oh, there it is.
Okay, thanks everyone. Sorry about that.
It's like programming.
Of course, stage fright.
It's like programming.
Yeah, all right.
Okay.
I'm ready. Wait, Mr. Martin, Judge Drummond, we'll let you start off the introductions and then we will move on. Welcome, everyone.
Well, thank you, Judge Sheehan. Welcome to everyone who's joining us. I'd like to divide this introduction into 3 sections. The first is what we're doing today, what we're looking at going forward, and finally, I have some thank yous at the end. So what we're doing today is we're doing our model civil virtual trial. We want to see what works, what doesn't work, and how we can fix it. And I've just told the jurors who are assembled here that the feedback they give us at the end is probably the most valuable part of this exercise. What are we looking at going forward? There are certain cases that could be ripe for a virtual civil jury trial. This will probably have to be starting out by agreement of the attorneys. I want to tell you that we appreciate all the attorneys being involved in this case agreeing to do this. They have stipulated that they waived any objection to this mode of deciding this particular case. However, in an actual case, there may be objections raised to a virtual trial. For example, unless the court system provides a uniform device that all jurors will have of the same size, offering the same clarity, there could be objections because the experience could be different for different jurors. For example, if a juror is watching the trial on a device that only has an 8-inch screen, will they be able to judge credibility as well as a juror who's looking at a device that has an 18-inch screen? So we appreciate the attorneys trying this out with us today. The next thing that we've done is that our working group, which is comprised of both federal and state judges, academics, and trial lawyers, we've broken the jury trial into 3 distinct pieces: jury selection, the actual trial, and jury deliberations. Because each one of those pieces could possibly be broken off to satisfy, in criminal cases, constitutional muster. In criminal cases, the defendant is entitled to confront the witnesses against him or her in open court. But is there a way, considering public safety, that we could break pieces off and still pass constitutional muster? For example, we could take jury selection and do it remotely. Instead of a juror having to get into a car, drive down to a courthouse miles away, the courthouse having to pay for mileage for that juror, the juror having to pay for parking and waiting hours in a jury room, could it actually be better for the remote juror to decide cases from their dining room table? We're hoping that even though we are called the Civil Jury Project at the NYU School of Law, that perhaps the work we're doing here today could help our colleagues on the criminal side of the bench. The final thing that we're going to be looking at is this particular platform. We believe that there are 5 or 6 different platforms out there that courts have adopted for trials and hearings such as this. Our hope is that by modeling this, that one or more of the platforms will see there is a need for a specialized platform for trials, because there are problems with this platform, and our newsletter on June 1st is going to list the tweaks or the additions that we would like to see on platforms that will allow these trials to proceed in a manner that is closest to the in-person trials that actually occur in the court system. The groups that I would like to thank is, first of all, our working group. There are too many to mention by name. They are comprised of, as I said, federal and state judges, academics, and trial lawyers. We would especially like to thank Chief Judge Jack Tudor and his group in the 17th Circuit in Broward County in Florida, because they have really laid the groundwork and are pioneers on these virtual trials. A link will be on our website to their work so you can see their model virtual trials. The other groups that I would like to thank Judge Sheehan and his entire group in Ohio for providing us the platform for today's exercise. I would like to thank the attorneys who are appearing today. That would be Stephanie Parker, Jennifer Wiesnecker, and Alex Gavin of the Atlanta office of Jones Day, and Eric Rosen of Rosen Injury Law, and Anthony Quackenbush of the Quackenbush Law Firm. This would not be possible without all the time and energy they put into this exercise. I want to thank the National Institute for Trial Advocacy for providing the case file. And finally, I would like to thank the NYU School of Law, their staff and administrators for helping us with the jury survey, and for all 92 of the NYU law students who agreed to adopt personas to represent a cross-section, a diverse cross-section of possible jurors for those trials. All of the successes of this exercise will go to this group. If there are any lapses, it is my fault. And with that, Judge Sheehan, I will turn it over to you.
Thank you, Judge Drummond. First of all, I'm in Cleveland, Ohio, and I'm wearing a mask, but there's only 3 people in the courtroom, so I'm taking this mask off. So you know why I have a court rule, everyone has to wear a mask, but I'm taking my mask off. We are here today. Before we start, I want to thank everyone. I want to thank Judge Drummond and the Civil Jury Project and all the lawyers for all their efforts and work to put into this case. We're ready to start off on a civil trial called Nita Liquor Commission versus Cut Rate Liquor and Jones. I'm going to have my bailiff open up court, Mr. Popovich.
Hearing, hearing, hearing. The Court of Common Pleas is now in session. The Honorable Brendan J. Sheehan presiding.
Thank you, Mr. Popovich. Ladies and gentlemen, I want to thank all of you for answering your jury summons. You are here, as I mentioned in the beginning, in a civil case. The title of the case is the Nita Liquor Commission versus Cut Rate Liquor and Jones. Representing the plaintiff in this matter is Mr. Eric Rosen. Representing the defense is Ms. Jennifer Wiesnecker. Ladies and gentlemen, this is a case, a civil case, brought by the Nita Liquor Control Commission against Cut Rate Liquor and Dan Jones for knowingly selling an intoxicated beverage to an intoxicated person in violation of Regulation 3.102 on June 5th, 2019 in the city of Nita. The defendants deny this allegation. As you know, the first order of business in our trial and our jurisprudence is the jury voir dire. And we appreciate all of you partaking in this jury voir dire by way of Zoom. I thank all of you for keeping your microphones muted while this process goes on, so there's no backlash going on in the microphones. And what I would like to do, just so you know, the plaintiffs in this matter have the burden of proof. So the plaintiffs will get to go forward first with the jury selection process, and then the defense attorney will get to follow up questions afterwards. With that being said, I'm going to turn it over to our plaintiff's attorney, Mr. Eric Rosen. Would you like to proceed?
Yes, Your Honor. Thank you, and may it please the court. And good afternoon, everyone. And first of all, my name is Eric Rosen, and I represent the Need of Liquor Commission. And I want to thank all of you for participating in this very unique trial. The right to a trial by jury is a fundamental right that's guaranteed by the United States Constitution, and you can see how important that constitutional right is by us, the lengths that we will go to continue that right and continue our civil justice system moving forward and having trials like this with this type of technology. So I want to thank everyone for participating. My time is limited. This is the part of trial where I get to ask questions. We get to ask questions of the jurors to find out different opinions and attitudes and experiences that you may have had in your life that may affect the way that you would decide the outcome of this case. And the point is, we want to find a fair and impartial jury. We want a jury that's not going to give an advantage or disadvantage to either side. And so, as I said, my time is limited, so I'm going to try to be as organized as possible and move through this quickly. If you could, all we ask is for there is no right or wrong answer, just give us your honest answers. So with that being said, I'm going to try to do some things here with the court technology and bring up a screen for you to look at. And the first question that I have, and if anyone has trouble seeing that, just raise your hand. But what I'm going to do is I'm going to ask a question, and then I'm going to ask you yes or no to this question. So for instance, some people have strong opinions about law enforcement. And my question to you is, how many of you, because of some type of experience that you've had, or maybe something that you've read or heard, you have negative feelings, even a little bit, towards police or law enforcement? And so that's the first question for the panel. And what I'm going to do is I'm going to go through each juror 1 through 12, and I'm going to ask you yes or no. Do you have any negative feelings towards police officers? So juror number 1, tell me, do you have any negative feelings just based on your life experience towards police officers?
No, I do not.
Thank you. Juror number 2, any negative feelings?
No.
Thank you. Juror number 3.
No.
Thank you so much. Number 4.
No.
Number 5.
No.
Number 6.
No.
Number 7.
Yes.
Thank you, sir. I appreciate that. And the negative feelings that you have, I just want to know on a scale, and that was juror number 6, right?
7.
Sorry, juror number 7. So tell me, on a scale from 1 to 10, 1 being the least negative feeling, and then 10 being just a strong negative feeling, where on the scale are you? A little bit or a lot?
About a 7 or 8.
7 to 8? All right. And so my question is this, sir. You're going to hear one of our witnesses is an investigator for the Need of Liquor Commission. He's the only witness that we're going to present. And what I need to know is, because of your life experience, is there a chance, even if it's slight, that you may that may affect the way you would listen to his testimony because he's an investigator, because he works with authorities?
I'm going to say no.
No? Okay. Are you able to set those feelings aside and listen to the evidence just as if he was any other witness?
Yes.
All right. I appreciate that, sir. Juror number 8. Any negative feelings?
No.
Thank you. Juror number 9?
Nope.
Juror number 10?
Yes.
All right. And tell me, Mr. Lewis, that's juror number 10, on a scale from 1 to 10, 1 being just a little bit of negative feelings, 10 being a strong feeling, where are you on that scale?
A 4.
4. All right. And so same question. Are you able to set those feelings aside and listen to the evidence and weigh that this our witness's testimony just as you would any other witness? Or is there a chance, even if it's a little bit, that your experiences and those feelings that you have would affect the way you listen to his testimony?
Yes, I can set them aside.
Thank you, sir. Appreciate that. Number 11, any negative feelings? Ms. Brown?
No. No.
Thank you. And juror number 12, Mr. Schuler, any negative feelings towards police officers?
No.
Great. Thank you. The next question that I have for the panel deals with the burden of proof. So everyone has probably heard in criminal cases, if you watch Law and Order or some other show like that, in criminal cases, the burden of proof is very high. It's beyond a reasonable doubt is what they call it. And so if the state is bringing a criminal case where someone's liberty is at stake and they may be facing jail time or prison time, the burden is very high. The state has to prove that case beyond and to the exclusion of every reasonable doubt. In a civil case like this, no one's going to jail. There is no penalty of going to prison or jail time. No one's liberty is at stake. And so in a civil case like this, the burden is much lower. And so the burden is by a preponderance of the evidence. And what that means is if we prove our case that a fact is more likely true than not true, we don't have to prove beyond to the exclusion of every reasonable doubt. We just have to tip the scales that it's more likely than not we're right than wrong. Some people feel like that's too low of a burden. We don't have to prove beyond a reasonable doubt. You can have doubts about, the proof that we've shown, as long as we prove that it's more likely than not true. So my question is this: how many of you feel that burden, it's too low? If someone's been brought to court, that if we're going to prove our case and hold them responsible, that it should be much higher. It should be a higher burden. And so why don't we do this? Juror number 1, how do you feel about that, the burden? How do you feel that it's too low?
I think it's okay.
You're okay? You'd be able to follow that more likely than not standard?
I can.
Thank you so much, ma'am. Juror number 2, Ms. Gomez, how do you feel about it?
It's the law, and I'll follow the law.
Wonderful. But nothing about it in your mind? You think maybe it's just a little bit too low and nothing like that? Thank you so much. Juror number 3, Ms. Springer. Any feelings against that burden of proof? Ms. Springer, are you there? Number 3? We're going to come back to Ms. Springer. Number 4, Mr. Honig. Any difficulties with following that burden, or you feel maybe it's just a little bit too low?
No, I don't think it's too low.
You're okay with that?
Yes.
Wonderful. Number 5, Ms. Dunn. How about you? Do you have any feelings that maybe it's just a little bit too low?
I think that's all right if no one's going to jail.
Okay, great. Mr. O'Leary, this is number 6. Any feelings, even a little bit, that the burden is too low in this type of case?
No, I think it's probably appropriate.
It's appropriate.
Yeah.
And when you said probably appropriate, is there any hesitation at all that you have about following that burden of proof?
No, I don't have any hesitation. I just mean I don't know much about the law, but it sounds good to me.
Okay, good. And that was juror number
6.
Juror number 6. Thank you so much. All right, and juror number 7. Any feelings about the law?
I can follow it today, but I think it should be higher.
You think it should be higher? Okay, but you'll follow the judge's instruction, right?
Definitely.
Okay. Number 8, Ms. Golub. Am I saying that right?
Yeah, you're saying it right. No problem with it. Thank you.
Wonderful. Number 9, Ms. Steele. Any feelings that the burden of proof for us is too low?
I think it's okay.
You're okay. All right, great. Thank you. Mr. Lewis, that's number 10. Any feelings that the burden of proof in this type of case for us to prove our case and prevail and win is too low?
No problem.
Great. You'll be able to follow that law and hold us to that standard of what's more likely than not true and than not true?
That's right.
Thank you, sir. Number 11, Ms. Brown. How are you, ma'am?
Yeah, I think that's fine.
Okay, good. Any hesitation at all when you say that?
No, that's fine.
Okay. All right. Well, think about it. Listen, at the end, I'm going to ask everyone if they have any reservations at all about it, about any of the questions that we've asked. And I want you to think about it just for a minute, but I'll come back. Number 12, Mr. Schuler. Any feelings that the burden of proof is just, a little bit too low? It should be higher?
No, I think it's the right standard.
Great. I appreciate that.
Counsel, let me interrupt you. Juror number 3's screen froze and she's back on if you want to ask her.
Yes, I was about to go right back to her. Thank you, Your Honor. And Ms. Springer, tell me, do you have any feelings that maybe the burden of proof, were you able to hear the intro to that, the burden of proof issue? Any feelings?
Yes, I heard everything.
Wonderful. Any feelings that maybe it's just a little bit too low?
No, I can follow the law in that respect.
Great. Thank you so much. And then we have just have a couple individual questions, and you can see I'm moving relatively quickly here. So thank you very much, everyone, for helping me streamline this process. Juror number 2, Ms. Gomez. How are you, ma'am?
I'm well. How are you doing?
Wonderful. So I have here that you were a prior juror.
I was.
And your experience, were you the foreperson of that jury, or?
I was not.
And how was your experience? Was it negative, okay, or was it good?
It was really good. And you know, when you get to be in person, they give you a lunch and, you know, do we get
Well,
that?
that'll be the next step. We'll be Ubering food to everybody who's on the Zoom trial. Thank you, ma'am. I appreciate that.
My budget's increased for that. Thank you.
This is for juror number 4, Mr. Honig.
Yes, it's Mr. Honig.
Honig, sorry about that.
That's okay.
I understand that you served in the military,
I did. I was in the Army Reserve.
and that was going to be my next question. Thank you for your service. I just wanted to know what branch that was. Thank you, sir.
Sure. Thank you.
Moving down our list, juror number 6, Ms. O'Leary. How are you?
Good, Mr. O'Leary, yes.
Mr. O'Leary, I'm sorry about that. Did you have a prior jury experience?
Yes, I did.
And tell me, was it a positive experience, good experience? Tell me a little bit about it.
Yeah, it was a positive experience.
Okay, were you the foreperson in that case?
I was not, no.
Okay. Thank you so much. This is juror number 7. I understand that you, we talked a little bit before, Mr. Williams, you have a close friend that sells alcohol?
Yes. So I used to work in a casino in downtown Cleveland. So I have a lot of friends and buddies that used to work for the bars there. And I also was a bar manager before. So I have a lot of friends in the staff that all like have that experience. Right now, I don't work in that space anymore, but I just have a lot of friends that did.
But that's something that you worked in during your time as a, where you were employed?
Yes.
So did you sell alcohol also?
I did sell alcohol, yes.
Okay. Would you sell alcohol to customers that come in and they're drinking and anything like that?
Like customers that have been drinking before? Like we sell alcohol.
Yeah, yeah. I'm just wondering if it's like a bar, like more like a bar, or if it's like a store.
It was like a bar.
All right. Were you
Bar
permitted to sell? Were you permitted to sell alcohol to people who were visibly intoxicated?
No.
What were some of the things that you would look for if someone came in and you noticed that they were visibly intoxicated?
Are they stumbling, slurring their words, struggling to make eye contact, things along that line?
All right. So you know that a little bit about this case is we've brought a charge against Dan Jones, who was for knowingly selling alcohol to someone who was intoxicated. And understanding that you had worked in that kind of a field, do you think that your experience may affect the way you would listen to the evidence in this case and decide the case?
No.
Do you think that the Needle Liquor Commission would be starting out even a little bit behind in your mind, or are we on an even playing field?
They'd be on an even playing field.
Thank you, sir. I appreciate that. Thank you. Number 11, this is Ms. Brown. How are you?
I'm good. How are
There
you?
you are. I understand that you have a close friend that was harmed by alcohol. Is that my understanding?
Yeah, I don't really feel comfortable answering this in front of everyone. Is there a way we can?
Thank you, Miss. Thank you, juror number. I'm sorry, I got to look at her number again. Number 11. I'm sorry. What I'm going to do, ladies and gentlemen, we are going to go to sidebar with juror number 11. During that time, it'll be outside of your presence. We're going to talk at sidebar. I'm going to go to a breakout room with juror number 11 and both counsel to talk about this issue at sidebar. Okay.
Thank you, Your Honor.
Okay. Thank you very much, ladies and gentlemen, for your patience. Mr. Rosen, you may continue.
Thank you, Your Honor. And thank you again for your patience, everyone. I just had a couple more questions. We're going to go to now, this is juror number 12, Mr. Schuler. How are you, sir?
I'm well. How are you?
Wonderful. Quick question. I understand that you served as a juror in the past.
That's correct.
And how was your experience? You heard me ask some other folks about their experience. Was it negative, positive? Where were you?
It was fine.
Were you the foreperson?
I was not, no.
Okay. And I also understand that you served in the military. What branch was that?
I served in the Navy.
In the Navy. Okay. Well, thank you for your service, sir. I mentioned before that I was going to, at the end of my questions, I was going to ask if anyone had any other things that when we were talking and other people were sharing some of the questions that I asked before, that if something popped into your mind that you think that, it may affect the way you would listen to this case, or you just want to say, hey, I wish Mr. Rosen would have asked me this question. Anyone here in the panel, if you can just put your hand in the front of the screen, anything that, is in your mind that, that you have any questions, anything like that, or anything that would affect the way you'd listen to the evidence in this case. And I see no hands going up. So with that, everyone, I really appreciate your time. I look forward to trying this case with you and presenting our evidence. Thank you so much.
Pass for cause, counsel?
For cause, Your Honor?
No, I said, are you passing right now? All right, you're wait. All right, we'll get to the challenges later. I just want to ask, you're passing?
I'll pass for cause for right now. Very
good. All right, for the defense, does defense have any questions for the jurors?
Yes, Your Honor, thank you.
All right, Stephanie, I hate to say this, but there's some echo. Is there a microphone you can get closer to or something? Because it sounds muffled. Something's muffled in your voice. All right, very good.
Let me check with my tech person for just a moment.
Sure. Yeah, I want to make sure the jurors can hear you loud and clear. So hang on, folks. Just want to make sure there's not a muffled noise going here.
Okay, is this better?
Yes, it is. Very
okay.
All right.
Thank you. So good afternoon, everyone. My name is Stephanie Parker, and I'm very proud to be here today representing the defendant in the case, Dan Jones. And I want to start by joining Mr. Rosen and thanking you for your service this afternoon as jurors in this case. I think you'll find that it's an interesting case, and we're looking forward to presenting our case to you. So I'm going to start by following up on some comments that you all made in your questionnaire. And then I'm going to go to asking questions to all of you as a group. So let me start with juror number 12, Mr. Schuler. Hello, Mr. Schuler. How are you today?
I'm well. How are you?
I'm fine, thank you. So you answered yes on the questionnaire to the question, have you or a close relative or friend suffered serious injury or harm as a result of the consumption of alcohol? Can you tell us about that, please, sir?
Yeah, I've had a few friends over the years who have been killed in drunk driving accidents.
And were these close friends of yours?
Yes, they were.
I'm very sorry for your loss. I'm going to need to ask you some questions about that. Is that okay with you?
Yeah.
So from your experience with your friends, are you coming into the case with any views about selling alcohol or the people who make their living selling alcohol?
No.
Do you have any negative views at all about serving on a case that involves the sale of alcohol?
No.
And I'm on mute.
Do you feel that you could put aside your experience with your friends in the past and sit in this case as a fair and impartial juror?
Yes, I can do that.
Okay, thank you, Mr. Schuler. And then Mr. Williams, hello, how are you today?
I'm good. How about you?
I'm fine, thank you. So I just wanted to follow up with you also. You told us when Mr. Rosen was asking questions about your own experience, and I just want to follow up and ask you, when you answered yes on the juror questionnaire to the question, do you or a close relative or friend have a job that involves the sale of alcohol? Were you talking about yourself, which you've already told us?
I don't currently work in a space where I sell alcohol. So I was talking about a friend, but I have worked in a space where I was selling alcohol.
Okay, so both you previously and a friend have had that experience. Am I hearing that right?
Yes.
Okay. All right, let me ask you first about your friend. Can you tell us a little bit about that?
It's just one of my friends I met through work. We would just hang out all the time, chat. Then afterward, we used to hang out, watch games together, at the bars, kind of in downtown Cleveland, just to catch up on a Cavs game or an Indians game. And so we came closer that way. But that's about it.
Okay, and what was your own experience?
So I myself worked at one of the casinos downtown, and then worked at a bar/restaurant in Cleveland, Ohio as well. So I just was responsible for selling alcohol to patrons at times, and just kind of running the bar itself. I was more of a manager at that point.
Okay, so either your own experience or what you've told us about your friend's experience, do you come into this case with any type of negative view about people who sell alcohol for a living?
No.
Thank you, sir. Now, I have a few questions that I'm going to ask of the entire panel. And I believe Mark explained to you before, if you want to raise your hand and if you have information to give me, if you just put your hand up, so we can all see it. All right. Does everybody understand? We can do that. Okay. Thank you. So here's my first question. Do any of you, for any reason whatsoever, and it doesn't matter, have any negative feelings about people who sell alcohol for a living, people who make money selling alcohol for a living? If you have any concerns about that, if you could raise your hand for me, please. It's juror number 1. And that's Ms. Labor. Hello?
Yes, hello. I perhaps should have mentioned this earlier. I do not drink alcohol for religious reasons. I don't necessarily blame anyone for drinking alcohol or selling alcohol. I just wanted to mention it that I do not have experience drinking alcohol.
So given what you told us about your religious views, and I appreciate you sharing that with us, given what you've told us about your religious views, is this maybe not the right case for you to sit in on?
I think that I can I don't judge people for their choices in drinking alcohol, and ultimately it comes down to what the law is. And so I think I can be impartial on this.
Does your religion teach that it's wrong for people to sell alcohol?
For people who follow the religion, yes. Or to sell alcohol, no. To drink it, yes.
Okay. All right. Thank you, Ms. Laidlaw. Anyone else want to raise their hand for that question? Okay, I see no other hands. Now, I want to ask this of the whole panel again. If you have something to say, please raise your hand again. Do any of you feel that you might be uncomfortable for whatever reason, doesn't matter, but for any reason, might feel uncomfortable coming back at the end of the case and entering a verdict in favor of the defendant, my client, who works in a liquor store? Does anybody have any concern about going back and telling your family or telling your friends that you sat on a jury and that you found in favor of the person who worked at a liquor store? Does that give anybody any concern at all? Juror number 12, let me ask you, does that give you any concern?
No, no concerns for me.
Anyone? Okay. I see no hands there. Thank you. Now, again, if you'd raise your hand, does anyone here believe that the sale of alcohol should be prohibited? See no hands. Now, I want to change topics and ask you about law enforcement. So if you heard the testimony of a law enforcement officer and you heard the testimony of a different person who was a civilian, tell me if any of you feel like that you would be more likely to believe the testimony of the law enforcement officer. This is juror number, let's see, I have several. Let's see, jurors number 4, 9, 5. Was there one other? 3. Do I have everybody? 4, 9, 5, 3. Did I miss anyone? Juror 8, okay. All right, let me start with juror number 3, Ms. Springer. Can you tell us about your feelings?
Yes, I'm pretty sure I could set them aside, but I did think it was important for me to tell you my husband was a police officer for almost 20 years, and my father-in-law was chief of police and worked in law enforcement for 50 plus years. So we have a lot of police officers in our family, and I do tend to think of them as pretty trustworthy, but I don't think I would necessarily immediately give them more credit, but I do tend to implicitly trust them, I think.
So would it be fair to say that based on your experience with your family members, if you heard the testimony of a law enforcement officer here, you would come into the case thinking that that testimony would be trustworthy?
I probably would, but I am aware that, still my family members who were in law enforcement talk a lot about, still making sure that policemen are living up to their duty. So I wouldn't say that I would automatically trust them completely, but I probably would be a little bit more inclined that way.
Thank you. That was Ms. Springer. So juror number 4, let's see where, there you are. Mr. Honig, did I pronounce that correctly?
Yes, you did.
Great. Okay. How are you this afternoon?
I'm good. How are you?
I'm fine. Thank you. Can you tell us about your experience with law enforcement officers and why you raised your hand?
Yeah, my son was in the New York State Police for 30 years. He actually just retired. And I similarly just have a positive view towards people in law enforcement. I think, my experience is that they've tended to be trustworthy people.
So coming into this case, of course, you haven't heard any of the testimony yet, but coming to this case, would it be fair to say that because of your relationship with your son and knowing about your son's work, that you might find the testimony of a law enforcement officer, you might just immediately think that that testimony was trustworthy? Would that be a fair statement?
I don't think that I would immediately find it trustworthy, but I think that I think it's fair to say that I would tend to find law enforcement testimony to be trustworthy, but I do think that I could set that aside and be impartial.
If you were in my position, okay, representing a defendant and not the law enforcement officer. If you were me, would you be concerned about your serving as a juror in this case?
No, I don't think so.
Okay, thank you. All right. That was juror number 4. I'm going to go to juror number 5.
Hello.
There you go. Ms. Dunn, hello, how are you?
Hello, how are you?
I'm fine, thank you. So same questions. Why did you raise your hand about believing law enforcement officers?
I don't have any close friends or family who are in the police force, but I think they're a positive force in my community and I feel safe around them. So I generally have a positive attitude towards the police.
Okay. So would it be fair to say coming into the case, you already have a positive view of one of the witnesses who's going to testify, the law enforcement officer? Would that be a fair statement?
Yes, I generally have a favorable attitude towards the police.
Okay, thank you. And that was juror number 5. That was Ms. Dunn. And let's see, next is juror number 8. Let's see.
Hi.
Oh, there you are. Yes. Hello, how are you?
Good, how are you?
I'm fine. So tell us about your experience and why you raised your hand, please.
I actually want to retract raising my hand. I don't think I would assume a favorable outcome or favorable testimony just because the person testifying was a law enforcement agent. So I think I'm more on the neutral side where I'd weigh the evidence.
Do you have a family member or a friend in law enforcement?
No.
Okay, thank you. And then finally, I have juror number 9. Let's see, Ms. Steele. Hello.
Hi.
How are you?
I'm good. How are you?
Fine, thank you. And you raised your hand. Could you tell us about the reasons why?
Yeah, I also don't know anyone in law enforcement. I just kind of think that a police officer has less of an incentive to lie. So, I can definitely, see what both sides say, and there has to be proof, but that was just why I rose my hand.
Okay. And so let me ask again. So do you have a friend or a family member who is in law enforcement?
Nope.
Okay. So if you heard testimony here from one witness who is in law enforcement and another witness who is not, just right now, just coming into the case, how would you tell me how you would view those two witnesses?
I mean, I think I can, look at them and try to treat them the same.
Okay. Thank you. And juror number 6, and that's Mr. O'Leary. Did you raise your hand also?
I did, yes.
Okay, I'm sorry. I think I missed it the first time. So if you could tell us, what is your experience and why did you raise your hand here?
Yeah, sure. I similarly don't have any close friends or family that are in the police. I just kind of generally have a positive view of the police because I guess they have decided to work to protect the public. So I think coming in, I might have a more favorable impression of someone who works in that area than a regular lay person. But I don't think that that's, an overwhelming view. And I don't think I wouldn't be able to make, a normal credibility determination.
So would it be fair to say, though, that already, before you've even heard any evidence, that you already have I'm going to use your words, a more favorable view of the witness who was in law enforcement?
Yeah, I think that's fair.
Okay. All right, thank you. So I want to switch gears and ask a question of the whole group on a different topic. You all heard the judge talk about the burden of proof, and you also heard some questions from Mr. Rosen along those lines. So I want to follow up. The plaintiff here, okay, that's the other side. So the plaintiff is represented by Mr. Rosen. The plaintiff has the burden of proof. My client is on the other side. My client is a defendant. My client has zero burden of proof. Nothing, zero. Does anybody have a problem with that? I see no hands. And right now, you all have heard zero evidence. You haven't heard from a witness. You haven't seen a document. You haven't seen anything at all. So I want to ask you if right now, if all of you can commit to agreeing that the plaintiff, represented by Mr. Rosen, is at zero right now. They have no evidence. They haven't done anything to prove their case. They are at 0. Do you agree with that? And if so, if you'll raise your hands. Raise your hands if you agree with that. So let's see, juror number 12, you seem like you were a little hesitant raising your hand. Were you? And can you tell me about that, please, sir?
Yeah. You said that they start off at 0, but I know nothing. So maybe to me right now, it's just as likely as not that one side has proven the case, I guess. I was just thinking about that.
Do you understand that one of the sides, and that's my client, the defendant, does not have to prove anything? There's nothing that needs to be proved by the defendant. Is that something that you can agree with?
Yeah, I understand that. That makes sense.
Okay. And right now, because you've heard no evidence at all, can you agree that the plaintiff has done nothing so far to try to meet their burden of proof?
Yeah, I agree with that.
Now, another question about the burden of proof. At the end of the trial, when you all are deliberating and deciding what your verdict is, if you find that the plaintiff has failed to meet their burden of proof on any one of the different things they have to prove a lot of different things. If they do not meet their burden of proof for any one of those required elements, would any of you have a problem coming back with a verdict in favor of the defendant because the plaintiff failed to meet their burden of proof? Okay. I see no hands there. Okay. Now, I have just one other quick question that I'd like to ask, and then that'll conclude my questioning. Do any of you believe that you have any special experience in determining whether or not a person is intoxicated? If you've ever worked in like a rehabilitation clinic or anything like that, and that's juror number 7, Mr. Williams. Can you tell us about that, please, sir?
Just my experience working in a bar and working in a casino, I just see people intoxicated many times a week. So I don't have any experience like dealing with it or treating it, but I'm just aware of it.
All right, thank you, sir. Anyone else? Anyone else? Okay, I see no other questions raised. So, Your Honor, that will conclude my questioning. And ladies and gentlemen, thank you very much for your attention this afternoon.
Thank you. Before we go to the next phase, I'm just going to ask, can I have a sidebar with counsel before we move forward? So I'm going to bring Eric. Ladies and gentlemen, when we do these sidebars, we're talking legal issues, nothing about anything but legal issues, and we're doing it outside your presence. So we're going to excuse ourselves from the room for a minute, and we'll be back in, okay?
Make sure she doesn't move.
All right. All right, I need to zoom camera. Thank you. Okay, ladies and gentlemen, thank you for your patience. The next order of business for this trial is each side, for the purposes of this exercise, is allowed to excuse one juror, for whatever reason they may choose. Please do not be offended if you get excused. This may not be the right case for you. This may be the right subject matter, but all of the parties appreciate your time and energy you've devoted during this process. And with that, the burden is on the plaintiff, so they get to go first in this process. Eric, would you like to exercise one of your preferences?
Your Honor, we accept the first 6.
All right, thank you. Ms. Parker, would you like to exercise any of your preferences?
Yes, Your Honor. We would like to strike juror number 5, Ms. Dunn. Thank you. Thank you.
All right, juror 5, you're excused. You just have to leave the meeting, and I appreciate that. Thank you. So then, with that being said, that would mean juror number 7 would be the juror in the first 6 jurors in this case. Is that correct, counsel?
Yes, Your
Yes,
Honor.
Your Honor.
All right. So juror number 8, which is Alex Gollop. Juror number 9, Julie Steele. Juror number 10, Avery Lewis. Juror number 11, Samantha Brown. And juror number 12, Edward Schuler. You will be excused. Now, I didn't ask the parties this question.
Your Honor, if I may interrupt?
Yeah, please. Thank you.
Sorry, I would like to use my only peremptory challenge on the new main panel.
Okay, go ahead then. Sorry.
It's okay. Your Honor, the plaintiff will strike juror number 7, Mr. Williams.
All right, so juror number 7 is then excused. Mr. Williams, I want to thank you for your honesty. I love the Cavs. I'm sorry you can't be with us today, but we'll excuse you, and you can leave the meeting. I thank you for your time and effort. So in serving as a juror, thank you. So juror number 7 is excused. So that means now juror number 8, 9, 10, 11, 12. Juror number 8, you're now on the panel. So 9, 10, 11, 12. And counsel, are we going to have alternate juror? Are we going to have one alternate juror, or do you want an alternate juror?
I think by agreement, there will be no alternates, Your Honor.
All right, just for the record, then there'll be no alternates. So juror number 9, 10, 11, and 12, you are excused. And thank you for your service, and thanks for your efforts in serving our community. All right, so now I'll wait for everyone, those jurors to leave the meeting. And now we have our 6 jurors. All right, ladies and gentlemen, the next order of business in this trial, yes?
Juror number 11, excuse.
Juror number 11, you were excused. Juror number 11. Yep, sorry, you get to go. Thanks. We had one sneaky juror hanging in there. All right, the next order of business in this matter is opening statements. Opening statements are not evidence in the trial. What the lawyers believe the evidence will show. It's kind of like going to a movie and watching a preview of the movie. And again, the plaintiff has the burden of proof in this matter. Mr. Rosen, would you like to proceed?
Yes, Your Honor, may it please the court. And good afternoon. You are the lucky 6. So thank you so much for participating and for being jurors in this case. And so in the city of Nita, if a company or corporation or a liquor store is going to sell alcohol to the public, they have to follow certain rules. And one of the rules, one of the most important rules is they are not allowed to sell alcohol, knowingly sell alcohol to someone who is intoxicated. It's not permitted. And so in this case, you're going to hear, and I want to tell you the story about what happened. And this was June 5th of last year. Officer Beer, he's an investigator for the Nita Liquor Commission. We're going to call him as a witness, was sitting outside. He was doing surveillance outside the Cut Rate Liquor Store. And what he saw was a gentleman standing on the corner across the street from the liquor store. And I hope I'm off mute. Good. standing across the liquor store, and he was leaning up on a post, and the guy just looked disheveled, and he watched him push off this post, and the man's name was Walter Watkins. And he starts to stumble across the street towards the liquor store. Halfway across the street, he falls to the ground, almost hits the ground, but he gets himself back up. He stumbles more. He falls again right on the curb, right outside the liquor store, and walks into the store. A couple minutes later, comes out. He had purchased. He walked right up to the counter. There's an exchange between the person behind the counter, which was Dan Jones, and he sees this exchange go on. Officer Beer sees this exchange go on, and Walter Watkins comes walking out with a brown paper bag with a bottle of wine in it, which he didn't have when he walked in. Investigator Beer stops him, and immediately, within 3 feet, can smell alcohol in this guy. And the guy his eyes were bloodshot and glassy. His speech, when he spoke, his speech was slurred. It was clear that this man was intoxicated. So Investigator Beer conducted something called field sobriety exercises, where he did, the hand to nose, and then, trying to pick up a quarter, and this guy was obliterated. And so after that, Walter Watkins was arrested, and Mr. Jones, who was behind the counter, Dan Jones, the defendant in this case, was cited for knowingly selling alcohol to Walter Watkins. And so, I'm going to show you, if I can, bring this up very briefly. There's only going to be one question on the verdict form, and hopefully everyone can see this. And the only question is, did the defendant, Dan Jones, knowingly sell intoxicating beverage to an intoxicated person in violation of the rule that everyone has to follow? And the answer is yes. And you're going to see, and this is going to be the verdict question that you have at the end of the case. I really don't think that there's going to be a dispute that alcohol was sold, that wine was in the bag, and that Mr. Watkins was intoxicated. The question really is going to come down to whether Dan Jones should have known these things when he sold that alcohol to Walter Watkins. And the answer is yes, absolutely yes. Dan Jones was responsible as part of his job at Cut Rate Liquor. He was not permitted as part of the policy, and he was trained on this. He can't sell alcohol if someone's staggering, stumbling, if they have an uneven gait. He can't sell to someone if they have an odor of alcohol. He can't sell if it's slurred speech, and certainly bloodshot, glassy eyes. And the evidence was, yes to each one of those things that Investigator Beer had observed immediately during the time that this alcohol was sold. And so when we talk about that burden of proof, and this is important, is it more likely than not that Dan Jones knew or should have known that he was selling alcohol to someone who was intoxicated? And the answer is absolutely yes. So when you get to the verdict form at the end of this case, we're going to ask you to answer yes, and we're going to present Investigator Beer in just a few moments after the defense counsel has their opportunity to give an opening. I appreciate your time. Thank you so much.
Thank you, counsel. Ms. Parker, on behalf of the defense, opening statement.
Thank you, Your Honor. May it please the court. So, ladies and gentlemen of the jury, hello again. Let me tell you my name again, Stephanie Parker, and I want to thank you for serving as jurors today. And I'm very proud to be here representing the defendant, Dan Jones. And Mr. Jones is the one who was sued by the plaintiff, represented by Mr. Rosen. Here's the most important thing you're going to hear about my client's case today, and that is that Dan Jones has no burden of proof. He doesn't have to prove anything. The plaintiff has the entire burden of proof, and right now the plaintiff is at 0. The plaintiff is required under the law to prove each and every element of his claim, and it is the plaintiff's job to bring that evidence to you this afternoon. Again, my client does not have any burden of proof in this case. So what will the evidence be? What are you going to hear from the witnesses this afternoon? Listen for this. The plaintiff has to prove every one of those elements shown here on the screen. Knowing, sale, intoxicating beverage to an intoxicated person. So listen for that evidence. If the plaintiff does not prove all of those elements during the trial, then your verdict has to be for the defendant, for my client, Dan Jones. So who are the witnesses you're going to hear from today? Well, Dan Jones, my client, is the only witness who knows what happened. Mr. Jones was inside the store. That's where he was working. He was the night clerk. He serves as works at the Naval Reserve during the day. He was the only employee working that night. Mr. Jones was there. He knew what happened. And he was inside the store. The only other witness that you're going to hear from today is Investigator Beer. Now, he's going to be called by Mr. Rosen, by the other side. Ladies and gentlemen, you're going to hear he could not see what happened inside that store. That's because he wasn't there. He was way down the street, sitting in a parked car about 65 feet away. And he's going to admit that he could not see inside the store. There are two other people who know what happened also, but they are not witnesses. You are not going to hear from them. They are not going to in any way support the plaintiff's burden of proof because they're not testifying. One is Mr. Watkins. He's the man who they allege purchased the bottle of wine. And then the other is Investigator Smith. Investigator Beer was not there by himself sitting in that parked car. He was with somebody else. He was with another investigator named Investigator Smith. And interestingly, you're going to hear about Investigator Smith did not sign the report. Only Investigator Beer signed it. So the only witness who has knowledge firsthand about what happened is Dan Jones, and you're going to hear him testify. So why is it that I say Investigator Beer couldn't see inside the store? What are you going to hear about that? Well, you're going to see these two exhibits that are there on the screen. Again, Investigator Beer was sitting in his car 65 feet away. So you may be thinking to yourself, well, what is 65 feet? It's about the height of a 5-story building. That's how far away it is. And not only was he sitting way down the street, you're going to hear him admit that his view inside the store was blocked by all of these advertisements. Officer Beer cannot prove that there was a sale of alcohol, and that's something that they are required to prove to you. He's going to admit that he did not see any money change hands, and he looked for a receipt on Mr. Watkins and did not find one. You're going to hear that he never administered a breathalyzer on Mr. Watkins, and he never even spoke with my client, Dan Jones. Now, what are you going to hear from Mr. Jones? You're going to hear that he cares about his job. This is his night job. He understands the law. He knows what he is supposed to do and what he cannot do. And he is aware of the consequences if he does not follow the law. And you're going to hear him testify that he is always careful with his customers. By contrast, my client, Dan Jones, was in the store the entire time. You're going to hear him say that he had multiple customers that night. He made multiple sales during his shift, and this is on June 5th. And you're going to hear him say he did not sell alcohol to anyone that he thought was intoxicated. So, ladies and gentlemen, you're going to need to decide whether the other side, the plaintiff here, under these facts, can prove every one of those elements that they're required to prove to you under the law. And we say it cannot, and we hope you'll say the same thing after you see the evidence. So thank you again for your service as jurors. We look forward to presenting our case to you. And at the end of the case, after you hear the witnesses, Mr. Rosen and I will have an opportunity to come back and talk to you again. And at that time, I'm going to ask you to return a verdict in favor of the defense. Thank you so much, Your Honor.
Thank you very much. Okay, is the plaintiff ready? Is everyone doing okay? Plaintiff, ready to call your first witness?
Yes, Your Honor. The plaintiff calls Investigator James Beer.
Okay. Mr. Beer, you want to raise your right hand?
Yes, Your Honor.
Do you swear to tell the truth, the whole truth, and nothing but the truth in this case now in hearing? You will answer unto God. Please say, I do.
I do.
All right, thank you.
Thank you.
Proceed.
Investigator Beer, you look a little bit different than your photo that was shown a moment ago.
Yeah, I've got my.
Go ahead and introduce yourself to the jury, please.
Yeah, hi. I am James Beer. Thanks for having me here today.
And James, Investigator Beer, what is your occupation? Who do you work for?
I work for the Nita City Liquor Commission.
And what is your job duty there?
My job duty is to make sure that all the liquor commission's regulations are kept up with, that the local businesses are in compliance with those regulations.
How long have you been with the Liquor Commission for?
Been there for 7 years total.
Prior to that, what type of work were you doing?
I was a police officer.
And for how long were you a police officer for?
About 7 years.
I want to bring your attention to the night of June 5th of last year, 2019. Where were you assigned?
I was assigned to an intersection at 7th Street in Jackson, in Nita City. And that's the intersection where the Cut Rate liquor store is located.
Let's go ahead and we'll bring that up. And so why were you out there? Why were you at the Liquor Commission? Or why were you at the Cut Rate liquor?
Your Honor, objection that calls for hearsay under Rule 801.
Let's we'll do a sidebar at this point. Do you want to do the? All right. Thank you. And for the record, that objection was overruled. You may continue, Counsel.
So Investigator Beer, tell the folks in the jury, why were you stationed out there that night?
We gotten some complaints of sales to intoxicated patrons at the store.
And so I'm going to bring up a demonstrative. This is in evidence, and we looked at this a moment ago. But where were you stationed, Investigator Beer, that night?
If you look to the bottom right corner of the diagram there, I was in the vehicle with the D under it, the letter D under it.
And at approximately 8:45 or so, what did you notice on the corner of 7th and Jackson Avenue?
On the corner of 7th and Jackson, I noticed a gentleman who I later ended up identifying as Walter Watkins. But at the time, I didn't know that. I just saw somebody that looked kind of disheveled. And he was leaning up against like a light pole at there you go, the arrow pointing at the northwest corner of 7th and Jackson. He was just leaning against the light pole there, and he looked kind of disheveled and dirty.
All right, and so what did he do after you noticed that? What did he do after you noticed him leaning up against that light post?
After I noticed him, he pushed off of the light post, and he started to walk south across 7th Street towards the Cut Rate liquor store. But he was all over the place. I remember halfway across the street, he stumbled and he almost fell, but he caught himself, and he kept walking. And when he got to the other side of 7th Street, he encountered a curb there, and I think he tripped over the curb, and he he almost fell to the ground, but he stuck his arms out to kind of brace himself, and eventually caught himself. But he was stumbling all over the place. on his way across the street.
From your observation, watching Walter Watkins walk across the street, what was your belief as to what was going on with him?
Oh, I thought it was clear that he was intoxicated, and I've got a lot of experience investigating, intoxicated people, and I thought that, from my perspective, it was clear as day that's what was going on.
And so after he fell in the middle of the road and then at the curb, where did he go?
Then he walked up to the front of the store, the front door of the store, and he stood there for a minute and looked in the door, and then he eventually opened the door and walked through inside the store.
And where did he go in the store?
He first went up to the cash register, and he had a brief conversation with the employee there in the store, who I later identified as Dan Jones.
And let me ask you something. Were you able to see the cash register, or the location, the front of the store where Dan Jones and Walter Watkins had that exchange?
I could see them from the waist up. So I could see them, but from the waist up.
All right. And what happened after that? Where did Walter Watkins go? What happened?
He walked away from the the area where the cash register was briefly, and then he came back shortly thereafter, and he was again interacting with Dan Jones at the cash register.
And from your observation, did it appear that he made a purchase?
Yes, because that's what it looked like was going on to me. And when he came out of the store, he had something in his hand that he didn't have when he went into the store.
And so when he left the store, what was in his hand?
He had a brown paper bag, which I later identified as carrying a bottle of cheap wine.
All right. Did you?
He didn't have that when he went in.
Okay. And then did you detain Mr. Watkins?
Yes. Once he got out of the store, he started to walk to the south there, as you can see on the diagram, the red dotted line. And at that point, I got out of my vehicle and I confronted him. And I looked inside the aforementioned brown paper bag, and I found the bottle of cheap wine. And because go ahead.
When you first approached him, what observation did you make about how he smelled?
Immediately, I could tell he smelled like alcohol. I think I was even 3 feet away. I could tell he reeked of alcohol.
And what about his eyes? What can you tell about his eyes?
They were red and glossy and bloodshot, all the signs of intoxication.
And how was his speech?
It was slurred. He was slurring his speech.
Did you perform something called field sobriety exercises?
Yes, I did. I asked him to, I asked him to do the standard field sobriety exercises, the finger to nose test. I had him bend over and pick some coins off of the ground. He wasn't able to do any of the field sobriety tests. He failed all of those, verifying my earlier impression that he was intoxicated.
From your observation, was he appreciably intoxicated from your view?
Yes, absolutely. And like I said, I have a lot of experience with this. This is what we do at the Nita City Liquor Commission. And I thought there was 100%, I was 100% certain that he was intoxicated, and I thought it should have been obvious to anybody.
Did you make the arrest?
I did. I arrested Mr. Watkins. That's right. And he was charged with public intoxication.
And where did you go after he was arrested? Did you go in the store?
Yes. After he was arrested, I went in the store and I issued a citation to the gentleman who I later came to know as Dan Jones for selling the alcohol to the gentleman who was obviously intoxicated.
And approximately how long after you stopped Watkins and then you did your field sobriety exercise and arrested him until you went back in to meet with Dan Jones? Approximately how long was that?
From when I first stopped Watkins, I don't know, maybe around 15 minutes.
Did you issue a citation to Dan Jones for knowingly selling alcohol to an intoxicated person in violation of regulation 3.102? That's
correct. Yep, I did.
From your observation, were you able to tell the distance between the desk of the clerk, how wide that counter was?
Yeah, it looked to be about 2.5 feet, something like that. 2.5 feet.
Is there any doubt in your mind from your observations and your interaction with Watkins that he was intoxicated?
0%, zero doubt.
Okay. Thank you, Investigator Beer. I have no further questions.
Thank you, sir.
Ms. Parker.
Yes, thank you, Your Honor. So Investigator Beer, good afternoon.
Good afternoon. How are you?
I'm fine, thank you.
Good.
My name is Stephanie Parker, and I represent Dan Jones, and I want to ask you some questions this afternoon. And I'm going to start by asking you about where you were the night of June 5th. You were not inside the store, were you?
No, I was not.
You were sitting in a parked car down the street, correct?
I don't know if I would say down the street, but I was sitting in a parked car. It was across the street.
Well, your car was more than 65 feet away from the entrance to the store. Isn't that correct?
That may be true.
Now, Dan Jones, the individual who worked in the store, and Walter Watkins, the one that you say went in and bought wine, they were standing in the back of the store, correct?
I don't know if you would call it the back of the store. They were standing at the cash register. So I guess how you define back, but.
They were not standing at the windows or in front of the door, correct?
There was some space in between the windows and the door and where they were. That's correct.
Now, according to your report that you prepared, you saw the man who turned out to be Mr. Watkins standing down on the corner at 8:45 p.m. that night, correct?
Correct.
And it was dark outside. It was 8:45 p.m., correct?
Correct.
And your only view into the store was through the window on the storefront, correct?
That's correct, yeah.
So, Your Honor, if I may show what's been pre-admitted as Exhibit 2.
Yes.
So, Investigator Beer, this is the window there at the store. You see that?
Yes, I do.
Now, in your own words, in the report you filed, your view sitting in that parked car was obstructed. That's a word you used. Obstructed by the advertisements on the windows, correct?
That's correct.
And I believe I heard you say, I know I heard you say, when Mr. Rosen was asking you questions, that you could see Mr. Jones and Mr. Watkins from the waist up. Remember telling the jury that?
Yeah, that's what I meant when I said it was obstructed. I couldn't see him from the waist down, only the waist up.
Well, actually, you have a copy of your report, correct?
I do, yep.
Actually, in the report that you filed, the report you prepared about this, you said you could see Mr. Watkins and Mr. Jones only from the shoulders up. That's what you said in your report, isn't it?
Let's
look
see.
at page 2. Look at page 2, sir, if you will. The first full paragraph, line 5. Well, starts on line 4. While Watkins is in the store, we can see him and Jones from the shoulders up due to the obstructing advertising in the window. Did I read that correctly?
You did. Yep, you did.
And in addition, the door itself, besides the advertisements we've talked about, the door itself had steel security bars across it, correct?
That's correct.
All right, now you were not by yourself that night in the car, were you?
No, I had my partner was with me at the time, a gentleman named Donald Smith.
And Mr. Smith did not sign the report that you prepared, did he?
I don't believe so, no.
You were the only person who signed the report, correct?
Correct.
Now, you saw from where you were sitting that there were other customers who went in and out of the store that night, correct?
That's correct.
And you also confirmed that Dan Jones was the only person who was working at the store that night, correct?
That I saw, yes, yeah, I believe that's true.
Actually, you said in your report that the store clerk, later determined to be Dan Jones, is the only one operating the business. You recall saying that?
Yes.
Now, you never saw Dan Jones hand a bottle of wine to Mr. Watkins, did you?
I never saw it handed to him, but I figure he must have because Mr. Watkins didn't have it when he went into the store.
Well, I'm going to get to that. So my question though right now is, sir, isn't this correct? You did not see Dan Jones hand to Mr. Watkins a bottle of wine, correct?
That statement is correct.
And you did not see Mr. Watkins pay for anything, including a bottle of wine, correct?
No, because I mean I could only see from the shoulders up, as you pointed out.
And after Mr. Watkins left the store and you confronted him, you looked for a sales receipt, but you could not find a sales receipt on Mr. Watkins, could you?
No, you're right. I do remember that.
Now, there's no evidence in this case of any photographs that you took that night, is there?
I don't believe so, no.
And there's no evidence of the security camera, any security camera footage taken that night, correct?
I think that's correct, yeah.
Now, you wrote in your report that when Mr. Watkins entered the store, he was wearing a raincoat. Do you remember that?
I do, yeah. I just remember it was kind of like a wrinkly raincoat, like a disheveled looking raincoat.
Okay. And you did not stop or search Mr. Watkins before he went into the store, did you?
No, not before he went into the store, no.
So you don't know whether Mr. Watkins already had a bottle of wine on him when he entered the store, do you?
Well, he wasn't holding one. I know that. And when he came out, he was holding one.
But you didn't talk to him. You didn't stop him. You didn't frisk him. You didn't ask what he had under his raincoat. You don't know whether or not Mr. Watkins went into the store carrying a bottle of wine, do you?
I think I actually do because he told me that he got the bottle of wine in the store.
Sir, you did not personally check Mr. Watkins at any time before he went in the store, did you?
No, I did not.
Now, when you stopped Mr. Watkins on the street after he left the store, you did not give him a breathalyzer test, did you?
No, I did not. I didn't feel like I needed to.
And there's no evidence here of a blood alcohol test either, correct?
That's correct. You're correct.
Did you bring that bottle of wine with you today to show the jury?
No, I did not.
Now, I want to switch to another topic. Going back to your report. So you have said in your report that before Mr. Watkins went into the store, so this is after you saw him at the corner, after you testified you saw him, walking and all that. But before he went in the store, in your words, Mr. Watkins paused and he straightened himself up. Correct?
Correct.
And those are your words. He, quote, straightened himself up. Correct?
Yeah, he'd caught it. He'd prevented himself from falling and he straightened himself up. Yeah, that's correct.
All right. And you did not observe Mr. Watkins trip or stumble while he was inside the store. Isn't that correct?
I couldn't really see that, no.
And your report that you prepared doesn't have anything in there about Mr. Watkins being unsteady or slurring his speech or anything like that while he was inside the store. Isn't that correct?
I wasn't in the store, so no, I didn't include anything like that.
Thank you, Investigator Beer. Your Honor, I have no further questions.
Thank you. Redirect plaintiff?
No, Your Honor.
All right, thank you, Officer Beer. Is the plaintiff going to be calling any other witnesses at this time?
No, Your Honor. At this time, the plaintiff rests.
Obviously, the parties agreed to the exhibits previous to that, so the admissions of the exhibits are in. So with that being said, defense, is the defense going to be calling any witnesses?
Yes, Your Honor, thank you. We would like to call Dan Jones, my client, to the stand.
All right. Get Jones in. Is the jurors doing okay? Everyone okay? All right, good. Okay, Mr. Jones, welcome to our court. Would you like to raise your right hand?
Yes, Your Honor.
Do you swear to tell the truth, the whole truth, and nothing but the truth in this case now and hearing as you shall answer unto God? Say I do.
I do.
All right, thank you. Ms. Parker, you may proceed.
Thank you, Your Honor. Good afternoon, Mr. Jones.
Good afternoon.
I'd like to start by asking you some questions about your job. Where do you work?
I am the night manager at a liquor store called Cut Rate Liquors. I work the evening shift there from 4 to midnight on weekdays. I'm also a member of the Naval Reserves.
And how long have you been a member of the Naval Reserves?
Actually, about as long as I've worked at Cut Rate Liquors. So about 5 years in total for both. I was full-time Navy for a number of years and then transitioned into the reserves, which allowed me to get a night job at Cut Rate.
So focusing on your job at the store, can you please tell the ladies and gentlemen of the jury, what do you do at your job?
Well, some days it feels like, what don't I do at my job? Because I'm the night manager, it's usually a bit of a skeleton crew that's there. So I'd say my primary role or duty is to make sales, to sell whatever the customers want to buy. But I also have to help with customer inquiries, help keep the store stocked. So I'm in the back room, bringing things out to the front, things of that sort.
So when you are you working inside the store?
Yes, absolutely.
And when you're inside the store working, are you watching what's going on outside the store?
No, I don't typically have that luxury. I'm usually busy working with the customers who are inside our store, answering their questions, making transactions, or restocking the shelves, or cleaning, or answering the phone. So I really don't have much of a chance to look out at what's going on outside the store.
Your Honor, if I may show what's been pre-admitted as defense exhibit number 1.
Yes.
So Mr. Jones, it's actually marked as number 1. There we are. Okay. Mr. Jones, I've put on the screen there a diagram. Could you just take a minute and use that diagram and tell the jury about the setup of the store?
Absolutely. Well, as you can see here, the store it sits on a corner, and we have 2 large windows on each side of the street at the corner there, and then sort of where those corner meets, there's a door. The door has a bunch of security bars on it, and the windows themselves have advertisements, logos, things like that on the tops and bottoms of them.
Okay. The night of June 5th, did you see Mr. Watkins walking up to the store?
No, ma'am, I did not.
And is it easy to see people who are outside of the store there?
No, ma'am, it is not. As I mentioned a moment ago, the windows, though they are obviously made of glass, there's a number of different advertisements, lighted signs on the tops and bottoms. So it's difficult to see out. And the door itself also has steel bars, security bars that run up the length of the door. So it is difficult to see out.
And Your Honor, if I may now exhibit to the jury what's been pre-admitted as defense exhibit number 2.
Thank you, counsel.
So, Mr. Jones, what does this photo show?
So this is actually a photograph of the window at Cut Rate Liquors. So this shows, as I mentioned earlier, the rows of advertisements, I guess they're posters, for lack of a better word, that we get from different vendors. And above those posters, you see a number of different fluorescent signs, or neon signs rather, and those are all inside the windows at Cut Rate.
Now, what's shown there on the screen is exhibit 2. Is that what the windows looked like on June 5th of 2019?
Yes, ma'am.
So I want to change gears now and ask you some other questions. We can take that down. Okay, thank you. Do you know whether or not there are laws on the books about selling alcohol to people?
Absolutely, of course. There are a number of different laws that deal with the sale of alcohol. Probably the one that everyone's most familiar with is the law against selling alcohol to minors. But there's also a law that prohibits the sale of alcohol to anybody who appears visibly intoxicated.
So I just asked you about what the laws are. Now I want to ask you about your employer, the company's policy. What is the company's policy about selling alcohol to intoxicated individuals?
Well, of course, first and foremost, any good company is going to follow what the law is. Now, in addition to that, at Cut Rate, there is a written policy about the sale of the sale of alcoholic beverages to visibly intoxicated customers. And that policy is that we do not do it.
And what are the consequences for an employee like yourself if you violate that company policy?
I could lose my job there.
Are you careful to follow the law in your company policy while you're at work waiting on customers and making sales?
Of course, absolutely. I'm very careful about all of the different rules and regulations that impact not only my job at Cut Rate, but my work as a naval reservist as well. I'm very careful about all of the things that apply to me, and I'm very careful to make sure that I am following the rules.
So I want to ask you now, in your own words, if you'd please tell the ladies and gentlemen of the jury what happened inside the store on June 5th of 2019.
On June 5th, again, as I mentioned, I worked the evening shifts. It was, I'll say, moderately busy, from 4 p.m. until around 10 p.m. that day. And there were a number of customers in and out of the store. I had made a number of sales during that time. It was, there was a lot going on. At no point do I recall ever making a sale to someone who appeared to me to be intoxicated.
Do you recall anything unusual that night?
No.
So do you remember having a customer or seeing a customer that appeared disheveled?
Yes, that's true. I did sell, I think it was a bottle of wine. I don't remember what kind, to a gentleman, say within 10 or 15 minutes of the investigator beer coming into the store. And I remember that gentleman was a bit disheveled. But that's all I remember.
Did you think that gentleman was intoxicated?
Of course not. Had I thought that gentleman would have not been a customer. That's the law and the policy at Cut Rate.
Do you remember anyone in the store the night of June 5th of 2019 who appeared intoxicated?
No, ma'am, I do not.
Your Honor, I have no further questions of this witness. Thank you, Mr. Jones.
Cross-examination.
Thank you, Your Honor, and may it please the court. And good afternoon, Mr. Jones. How are you, sir?
Good afternoon. Doing well.
First, I want to thank you for your service in the Navy. We appreciate that.
Thank you.
So I want to switch topics. I want to focus on your work at the Cut Rate Liquor Store in the evening of June 5th, 2019. You were working that night, right?
Yes, sir, I was.
You were on the 4 to 12 shift?
Yes, that's right. I worked the evening shift.
So if someone walked in at 8:45 p.m. and bought a bottle of wine, you'd be the one that was working behind the counter, right?
Sure.
No one else?
No, not that evening.
And you said just about 10 to 15 minutes before Investigator Beer came in and issued the citation to you, you sold a bottle of cheap wine to someone who looked disheveled, right?
Yes, that's right. I do recall that.
All right. And so you're not saying you didn't sell wine to the guy who was ultimately arrested, Walter Watkins. You're saying you just don't know?
I'm saying that I don't recall Mr. Watkins one way or the other.
Fair enough. I want to talk a little bit more about the law. You said you are aware of the law. You can't knowingly sell alcohol to someone who is intoxicated, right?
That's right.
And you know that that Cut Rate has its own policies in place to make sure that doesn't happen, right?
Yes, sir, that's correct.
In fact, that's something that you've been trained on about, do not sell alcohol to someone who appears intoxicated. True?
That's right. Yes, sir, that's right.
That's a responsibility that your employer puts on you so that you don't violate the law, right?
Of course.
And so that you don't violate the policies of the company. True?
Yes, sir.
Part of that policy in what's required of you as an employee is to look for those signs to see if someone is intoxicated, right?
That's right. The training that we receive deals primarily with what we're able to observe as members of the sales force there at Cut Rate.
Sure. So one of the things that you've been trained on is to listen to someone if they have slurred speech. That may be a sign of intoxication, right?
Yes, sir. That's what we were trained on, and that's part of the policy.
And another thing that you are required as part of your job to look for is a smell of alcohol coming off the person, right?
Yes, that's true.
And another thing that you need to look for is if the person has bloodshot eyes. That's another indicator to you as an employee. This person might be intoxicated, right?
Yes, that is one of the possibilities for someone having bloodshot eyes. Yes,
and you're also supposed to look while they're walking through the your store if they have an uneven gait. You're supposed to try to observe that, right?
Well, we are trained that if a person has an uneven gait, or if we happen to notice it, to keep that in mind as we make our decisions about whether or not we're going to serve that customer.
Sure. And so if someone comes in and they have slurred speech, bloodshot eyes, and they smell like alcohol, you're not supposed to sell alcohol to them, right?
Well, it's a determination that we make based on all the facts and circumstances. Had someone come in to Cut Rate and looked and acted the way you described, I would not have served them, no.
Sure, if they had bloodshot eyes, and slurred speech, and alcohol smell, you wouldn't serve them, right?
No, I absolutely would not have.
Good. And so you already said that you did sell alcohol, a bottle of wine, about 15 minutes before the officer Investigator Beer came in and issued you the citation, right?
Yes, that's correct.
You are not only responsible to know whether someone is intoxicated when they come into the store, but your employer wants to ensure that you should know if they're intoxicated by looking for those signs, right?
Right, that's part of the training. The policy and the training that goes along with it is meant to help us identify customers who come in who we should not serve.
You were given the opportunity to give a statement that night to Investigator Beer, and you chose not to, right?
Yes, that's right. Another policy at Cut Rate Liquor is to not give statements right away to investigators who come into the store. And I followed that policy like I followed all of the other policies that are in place at Cut Rate Liquor.
Sure. So Cut Rate Liquor has a policy of not cooperating with the Liquor Commission when they're conducting an investigation, right?
There's a policy that says that we're not to give statements to right away to investigators from the Liquor Commission.
Okay. See no evil, hear no evil, speak no evil, right?
I'm sorry?
Nothing. No further questions, sir. Thank you so much.
Any redirect, counsel?
No, thank you, Your Honor.
All right. Ladies and gentlemen, before we go to the next phase of this trial, I am very conscious of jurors paying attention and making sure you give us your full attention. I think this might be a good time to everyone mute your computers and allow a 3-minute recess to use the restroom, stand up and stretch. So before we go to the next phase of the trial, which is closing arguments. Is there any objection by any counsel to taking a 3 to 5 minute recess? And just mute your computers and wait for all jurors to come back to make sure everyone's okay. All right?
Thank you, Your Honor.
Thank you, Your Honor. No objection.
All right, well, 3 to 5 minute recess. All right, thanks. Michael, you doing okay?
Doing well, Judge.
All right, good.
How about you?
Good. I just want to make sure you're hearing okay and everything's, we're not putting you to sleep, are we?
Not at all. You've woken me up.
All right, good. All right, I think we're just waiting for a couple of the jurors to come back and the lawyers Did the lawyers disappear?
Yeah, they'll have to come back.
They came out of the room,
No, I think they just,
deleted themselves? Or-
yeah. Where did they go?
Was that a well rested, well needed jury break? I'm looking at my jurors. They look refreshed. All right, good. All right, plaintiff is back. And as soon as we get defense counsel back, I might just, okay, good. Great, we got everyone, we got just waiting for one juror. Can I do a sidebar with the lawyers real quick? I just want to ask a question before we go to the next thing.
I'll just do it from the side.
Okay, we're ready to roll.
I'm having trouble hearing it. I know, it's hard.
Okay, ladies and gentlemen, thank you. I see the doctors look more refreshed and smiling on your face. So that was a good recess. All right, ladies and gentlemen, the next order of business of this trial is closing arguments. Before we get to closing arguments, the parties have agreed to allow me to read you the law that applies to this case before you hear closing arguments. This is a law that applies. The parties will be then able to reference the laws. This will help you while listening to the closing argument. The elements of a civil complaint under regulation 3-102 are as follows. 1, knowing, defined as knew or should have known. Sale of intoxicating beverages, beer, wine, forfeited wine, or spirits. 4, to an intoxicated person, one who is appreciably impaired from an intoxicating beverage. The commission has the burden of proving each element by a preponderance of the evidence. If you find the commission has proven each element by a preponderance of the evidence, your verdict should be in favor of the commission. If you find that the commission has not proved one or more of the elements by a preponderance of the evidence, your verdict should be in favor of the defendants. Preponderance of the evidence means that the proposition is more likely true than not true. With that being said, ladies and gentlemen, that is a law in this case. I'm going to allow the plaintiff, again, has the burden of proof. First. Then Stephanie will be for the defense after, and then the plaintiff will have their final close. I just would ask that everyone mute their phone or mute their account so there's no brief back noises going on, and then everyone can be heard. All right, Stephanie, I think you need to mute your computer. There you go. All right, Mr. Rosen, are you ready for closing argument?
Yes, Your Honor. And thank you. May it please the court. Everyone can hear me? All right, great. So I'm going to get right to it because my time again is limited. So what I'd like to do, hopefully everyone can see this, is talk about what you're going to have in just a few minutes, which is the verdict form. And this is how you answer whether or not the defendant violated Rule 3.102. And the answer to this question, and the judge gave you an instruction, we're going to talk about it in a little bit, but there's absolutely no doubt that Dan Jones knew or should have known that he was selling alcohol to someone who was intoxicated. There's absolutely no doubt. And so the answer to that question is going to be yes. The answer to that question is yes. And we talked about the burden of proof. We don't have to prove this case. The commission isn't here to prove this case beyond and to the exclusion of every reasonable doubt. The law is, and the law that you all agreed to follow during jury selection is that we have to prove this case by a preponderance of the evidence. We have to tip the scales slightly in our favor. What's more likely true than not true? And you know, one of the things we asked of jurors is whether you could set aside some of your experiences. And one of the things you don't have to set aside when you're a juror in a case like this is good old-fashioned common sense. Good old-fashioned common sense, because if it looks like, there's an old saying, if it looks like a duck, if it swims like a duck, if it quacks like a duck, it's probably a duck. That's not an eagle. It's not a falcon. It's not a flamingo. You know, we have common sense. And one of the things that we have is, you know, that's an old saying. And just like the evidence that we have in this case, Investigator Beer, who's worked for the commission for a number of years and is a police officer, what he testified to is just shows that this man who walked into the cut rate liquor and purchased wine from Dan Jones was obliterated. The guy was obliterated. He was stumbling across the street. He had an odor of alcohol immediately apparent from 3 feet away. And you heard that the actual countertop is only 2.5 feet. He had slurred speech, bloodshot glassy eyes, all of the signs that someone is intoxicated. And so when you answer that question, whether he knew or should have known, you know, the answer is absolutely yes. That's his job to know. That was his job to know, to not sell to someone who was intoxicated. And you heard the reason why Officer or Investigator Beer was there in the first place was because they were getting complaints that this store was selling to people who were intoxicated. You know, so when you answer the question, you know, whether he knew or should have known, the answer is yes. When we talk about a sale, you know, you heard during cross-examination that there was no receipt in the bag, you know, or that the wine was underneath his jacket. You know, come on. Dan Jones admitted on the stand just a few minutes ago that he sold a cheap bottle of wine to a guy who looked disheveled 15 minutes before Investigator Beer came in to cite them. You know, we know that he sold it, so we met that element. We know that it was an intoxicating bottle. It was wine. Dan Jones admitted that himself. And we know from the investigation from Beer that Walter Watkins was drunk. He was intoxicated, visibly intoxicated. You can't make bloodshot eyes disappear when he walked into the store. You can't make the smell of alcohol disappear. You can't make slurred speech just disappear. You know, and so, you know, when you answer this question, the answer to that question is yes. And Dan Jones himself he has a responsibility. And you know what's at stake here? He said it to you on the witness stand. If he gets caught, if he admits to this, he's going to get fired because he violated the policies. And what's the policies that they have at Cut Rate Liquor? Do not sell if someone is staggering or stumbling or uneven gait. Don't sell if they have an odor of alcohol. Don't sell if you have slurred speech. Don't sell if they have bloodshot glassy eyes. I mean, his job is to make sure he doesn't sell to someone who's intoxicated. And so it's not just whether he knew, it's whether he should have known, and he had a responsibility to know. And, you know, listen, it's not a defense. You know, I asked him, did you even cooperate with, you know, Investigator Beer when he came in? He said, no. He said, no, I didn't give a statement because that's another policy of Cut Rate is we don't talk to investigators. You know, there's another old saying, you know, it's not a defense. See no evil, hear no evil, speak no evil. That's when you know you've done something wrong, but you shut your eyes to it, you know, or turning a blind eye. Those aren't defenses, or sticking your head in the sand and pretending like you don't know. You know, he admitted he sold this alcohol to Walter Watkins, and Walter Watkins was done. And so use your common sense when you make the decision in this case. If it looks like an intoxicated person, it walks like an intoxicated person, talks like an intoxicated person, smells like an intoxicated person, Dan Jones should have known that Walter Watkins was intoxicated. And that's why he's here today, because he sold alcohol and because there were complaints before and he got caught. End of story. And so the answer to each one of these questions is yes, we've met our burden of proof of more likely than not, he should have known. More likely than not, he sold that alcohol. He was the only one in the store. We know that it's wine, it's an intoxicating beverage, and we know that it was to an intoxicated person. And all we have to prove is that that it was appreciable that this guy was intoxicated. Bloodshot, glassy eyes, slurred speech, the smell of alcohol coming off this guy. He couldn't do any field sobriety exercises. So when you answer this question, the answer, we've talked yes to all of those things. The answer to this question is yes. And I want to thank each one of you for your service in this case. We truly appreciate it during this unprecedented time. Thank you.
Thank you, Mr. Rosen. Closing argument on behalf of defense. Ms. Parker.
Thank you, Your Honor. May it please the court. So, ladies and gentlemen, before you heard from Mr. Rosen, you heard from the judge himself that the plaintiff has the burden of proof here, and that the law requires the plaintiff to bring in evidence in this courtroom to prove every element of their case. And the bottom line here, what I'm going to spend my time talking to you about, is that the plaintiff has not proven its case. The plaintiff wants you to focus on what happened outside the store. They want you to focus on what may have happened at the street corner or down the street or out on the sidewalk, but that's not what's important. What's important is what happened inside the store. So why is the plaintiff doing that? Why are they focused on what happened outside? Well, the reason for that is they only have one witness that they brought to you, and that's Investigator Beer, and he does not know what happened inside the store on June 5th. And he admitted that when I questioned him. The only witness who knows what happened inside the store is Dan Jones. Remember these two exhibits that you saw during the trial? So this is the diagram and the photographs of the outside of the store. The plaintiff's witness, Investigator Beer, admitted when I asked him questions that he was not in the store. He admitted that he was over 65 feet away. He admitted he was sitting inside a car at 8:45 at night when it was dark. He admitted in his words, that his view inside the store was, quote, obstructed by all these advertisements you see. And then remember, he tried to say, well, he could see Mr. Jones and Mr. Watkins from the waist up. And I had to show him the report that he prepared in this case, where he said in his report, he could only see them from the shoulders up. There was no corroboration for his testimony. There was somebody else there in that car. That was Investigator Smith. Investigator Smith has not testified. Investigator Smith did not sign that report. And Investigator Beer's eyewitness testimony was limited to what he saw sitting in the car way down the street in the dark. And that is not enough for the plaintiff to prove its case. So let me go over a quick review of these elements that the plaintiff has to prove. And the plaintiff is required to prove every one of these to you. Let me start by talking to you about the last three, and then I'm going to come back and talk to you about the knowing element. So the last three. No witness saw Mr. Watkins purchase wine. There was no sales receipt, even though the investigator looked for it on Mr. Watkins after he left the store. There was no sales log in evidence. There was no security footage in evidence. No one tested the contents of the bottle. The investigator did not bring it to court so we could look at it to see whether it was really wine. There was no breathalyzer here. There was no blood alcohol level test. And there was no testimony from Mr. Watkins himself. So ladies and gentlemen, there's been a complete failure of proof on those three elements that I've been talking about so far. Now let me go back to the first box you see on the screen. The plaintiff also has to prove that Mr. Jones knew or he should have known that Mr. Watkins was intoxicated. Well, you don't even need to deal with that because they haven't proven the other elements. And they have to prove every one of these, all four. But with respect to that first box, again, remember, Investigator Beer was not inside the store. He cannot testify as to whether Mr. Watkins appeared to be intoxicated when he was actually inside the store. He has no idea what Dan Jones saw. He was not there. In fact, and this is very important, the investigator told you, he admitted that Mr. Watkins changed his behavior from the way he acted at the corner of the lamppost, walking down the street before he entered the store. He changed his behavior. You heard Investigator Beer admit when I asked him questions that Mr. Watkins paused and I'm going to use the investigator's own words, he straightened himself up. He pulled himself together and then he went in the store. Ladies and gentlemen, the best witness to say what Dan Jones knew is Dan Jones himself. He told you he cares about his job. He told you he understands the law. He's aware of the consequences if he doesn't follow the law. He told you he's always careful with customers. Mr. Jones did not knowingly sell liquor to an intoxicated person. There has been a complete failure of proof on every one of these elements in the case. But again, the only thing that you have to find is a plaintiff failed to prove any one of them, and that means a defense verdict.
Thank you.
So Mr. Rosen had that little cute saying, which I think all of us have probably heard before, but if it walks like a duck, you remember all that, okay? The problem here, though, is that Investigator Beer was outside. He didn't see the duck inside the store. He didn't hear what the duck said inside the store. He didn't see how the duck walked inside the store after he had straightened up. And you didn't hear from the duck himself, and that was Mr. Watkins. So, ladies and gentlemen, the plaintiff simply has not proven its case to you. And for that reason, I'd respectfully ask you to return a verdict in favor of the defense, in favor of Dan Jones. I want to join Mr. Rosen and thank you for your time and your attention this afternoon. We very much appreciate your service. We hope you've enjoyed this experience. Thank you, Your Honor.
Thank you, counsel. Final close, Mr. Rosen.
No rebuttal by agreement, Your Honor.
Okay, very good. Okay, ladies and gentlemen, rounding third and heading home. All right. First of all, you've heard the law that applies to this case. If you have any questions about these instructions, it first should be discussed in the privacy of your jury room. If you disagree as to the meaning of these instructions, it's possible that you could ask a question, and I just ask that the foreperson writes out that question. So first of all, when you go back into your jury room, we will place you in a jury room. The first order of business would be to select one of your number to be the foreperson. Once the parties have agreed, once you've selected a foreperson, to reach a verdict in this matter, all six of you will need to be in agreement on that verdict. When you're back there, you should not divulge to anyone the status of your deliberations, not to me, not to anyone of my staff, nor will anyone know your verdict till it is announced back in this open court when you notify us you've reached a verdict. Members of the jury, after you reach a verdict, you will be asked, there's the verdict form that you've been provided for in your email. You'll be asked whether or not this is your verdict, and I will poll each and every one of you, and the parties have agreed that will waive the signature requirement on the verdict form. The law in constituting 6 jurors contemplates that each and every one of you will give your individual consideration and judgment upon this evidence. The rules of law that were explained to you here in these instructions are binding upon your individual conscience and judgment of each member of this jury. Ladies and gentlemen, having carefully weighed all the evidence in this case, apply the law as stated in these instructions. Let your verdict be fair and impartial, thus assuring you've been mindful of your oath to well and truly try and true deliverance make in this matter your verdict. The verdict that you as a body reach is your own. There's no right or wrong verdict, so long as you consider all the evidence, listen and follow the instructions of law that I have given you. Ladies and gentlemen, this case is now in your hands for a verdict, and Andrea will place the 8 jurors in the jury box along with our bailiff, Michael. All right. All right, I think we're unmuted now. Stephanie, you need to, I don't know where our plaintiff went. Did you put him in the jury room?
So Eric went to the sidebar. He got a notification saying it was open, so I think he went to the sidebar.
Okay, we got to send Eric back out. Here he comes.
Here comes
All right,
Eric.
very good. All right, so, well, what's your take, folks?
Excellent job. Attorneys are always worried that video is going to dampen persuasion, but I think this shows that energy combined with great visuals can be just as persuasive. How do you two feel it went?
I enjoyed myself. I had a good time.
I tell you, I think we all ought to invest in litigation tech companies because I definitely needed the tech help here. They were incredibly helpful to me, and I know that you all had different people helping you as well. So I think that was critical. If I had quote a real one, I would definitely want to get people with me the whole time. But I enjoyed it also. Eric's a great lawyer. I know him previously, and he's a wonderful lawyer. He did a great job today. And when I saw his duck exhibit, I was like, I know, there goes Eric.
Well, you attacked it pretty good, so.
Well, the one thing that I found interesting is Brendan, I was going to question you having a long camera shot as opposed to.
Hi, Judge.
Yes.
The jurors have a question.
Oh, all right. Well, let's. Do you want to have the question written out or read it to us, or do you want?
I can go ahead and read it to you. It says, "What will happen to him if we find him guilty?"
All right, counsel, how do you want to respond to that?
That you can.
I think they can't consider it.
Not relevant. Yeah,
I would agree.
You're fine to see if he violates the law or not, right? So I'm going to write out, or should I respond in writing to the question, or should we bring the jury in to tell them the answer? Any recommendation?
Yeah, I think maybe bring them in and just say, you need to decide this case based on the facts and the law without regard to that. That's my job. The court's job deals with the outcome.
Yeah. All right. Any objection to that, Stephanie?
No. That'd be
All
fine.
right. We'll bring in our 8 jurors.
I will.
You could stay, Mark. You're good.
I will get out of this, and then I will come back on.
All right. Hopefully they know to come back in, right?
Is the bailiff supposed to tell them to come back in?
The room will automatically.
The room's going to
close.
automatically close. We put a timer on the room in case they didn't know how to get out of the room, so they'll come back out. Okay. Welcome back, jurors. We received a question, and the question, if I was correct, states, what will happen to him if we find him guilty? And ladies and gentlemen, I'm going to tell you that your job as a juror is to decide this case based on the facts and the law. As for punishment or as for what will happen to him, that's up for the court to decide. Your job is solely to determine if in fact this case was proved by a preponderance of the evidence, those elements. And as for everything else, that will be up for the court. With that being answered, I'm going to then send you back into your jury room to continue your deliberations, okay? All right. We got one more juror, Sarah. One juror hanging on. Did she get the invite? There she is.
There we go.
All right.
Okay, so Brendan, as I was saying, I was kind of concerned about the long view because, you know, I thought you should be of equal size, but then I went back on that because, you know, the jury and the attorneys, especially the jury, is looking at every facial expression the judge makes. And, you know, sometimes it's hard to hide, especially when you think that somebody should be objecting to something or, you know, that you're just absolutely stone-faced. So I'm thinking the long view might be better. What, Stephanie, Eric, what do you think?
I think the distance right now looks good. There was a point where it was much farther back. I couldn't see the judge at all. So this distance looks good.
I agree. It's hard for me to understand. I couldn't read your lips. I couldn't tell exactly when you were talking when it was a longer view.
Yeah, the way the courtroom camera was, the two Mondo pad, we got these, wait till you see this on video. There's like great 86-inch Mondo pads in the courtroom, and they pulled them back. And as I was looking, I thought, oh, and Darren said we should make you bigger. So we pulled us back in a little bit more. So, and then we had Andrea down below here in the well, who was moving you in and out of rooms and trying to do that while we were there. So it was kind of an interesting thing. One of the things, yeah, stand up, Andrea. One of the things Andrea mentioned, though, yeah, there you go. One of the things Andrea mentioned, which was interesting, we should have had another room, we learned. Andrew, you want to tell them what we figured out?
Yeah, so we really probably should have had a courtroom breakout room because like now when I have been putting the jurors into the jury room or before when we went to sidebar and we had the juror with us, I needed to move her out the next time we went to sidebar, but there was no place for me to move her to except to the jury room. So, you know, luckily she figured it out and she came back. But we do need that one main courtroom as a room that everybody can be assigned to.
Yeah, and we didn't think we needed that. Yeah, go ahead, Mark.
Well, what hopefully the software companies are going to pick up on is for a platform where, Brendan, you can do this from the bench, where you will have rooms where you can take your cursor and move the tiles over immediately. So there's no lag time between you telling Andrea to do something and then Andrea doing it. And I think that would be the ideal if we can get something like that from one of the software companies. The other thing I wanted to say is, Alex, I know you're on the line listening. You can show yourself if you wish. I want to compliment you. You had the best eye contact with the camera. And it's very hard to do because you've got to look at that little dot that's up at the top as opposed to the more distracting faces that are all over the screen. And your eye contact as the witness was excellent.
Yeah.
I thought you were talking to me as a juror.
That was good. I thought the same thing. The one thing I had a question about, and I know we had the virtual backgrounds in the back, but a little bit of that ghosting issue.
Yeah.
And that was, I mean, it wasn't not the lawyers per se, but the jurors ghosting was,
yeah.
They were moving around and I saw partial faces. I thought, oh, that's interesting. And I don't know if we care if the juror's background is in their backyard or in their kitchen or in their living room. That's something to think about. Did that ghosting affect, as I'm looking at the jurors for their responses to questions, that affect you guys? I don't know.
Go ahead.
No, I would be, I think I'd have a little bit of a privacy concern for jurors being shown, their backgrounds and all being shown. I mean, that's one thing I've noticed, not with jurors, but just with lawyers and clients and all on Zoom meetings over the last few weeks is I've seen like books people are reading, behind them and all sorts of things like that. So, and, identifying maybe family members or photographs or something. So I think I would have that concern.
Yeah, Darren Tom's our.
So I agree with you. There should be a background there so you don't know where they are, but it should be suggested strongly that they not have a window behind. As long as there's a darker or solid background, the ghosting is much less. But if they move and there's light behind them, that will really affect them.
Yeah, and they look like they're on 60 Minutes in a witness protection program.
Right.
And Mark, I texted you a picture from behind the bench here so you can see the monitors. It's on your phone.
Oh, great. Thank you.
Andrea?
So the one other thing about the jurors is that as we've been going through this, some of them were occasionally drinking. Some of them were eating. I felt at one point that one of the jurors was eating a bowl of cereal, it looked like. And I just think it's interesting. It's something to think about because that's not something that they can obviously do in a courtroom. For their comfort, do we want them, would you want them to be able to do that? Or would we say, if this was a real trial, please refrain from eating during the proceedings or something like that? I don't know, but I thought it was interesting.
Yeah.
Yeah, I would think to not let, not have them eat on breaks. I mean, drinks and water or coffee. I mean, typically in trial, the jurors do that anyways. The judge usually lets them do it. So.
How about that built-in restroom break? I had not thought about it, and I was looking. I'm like, oh my gosh, I have to go to the
That was good.
Good idea.
For a couple of hours, I'm like, I better make sure. Might as well treat it like, the jurors might have to use the restroom too. So, I don't know how that. I didn't want to surprise anyone on that, but I was kind of like, hey, we need a 3-minute break.
Yeah, I think the studies on screen time say that 4 hours is probably the maximum that you can do a day.
A day, right?
And still be effective. When video depositions came in, everybody was worried that they would be less effective than in person. But in this day and age, most of the jurors, everyone's getting their information through a screen. So that's kind of leveled off. The problem is the screen fatigue, and everybody's pegging it at about 4 hours.
I thought the only technical when Stephanie, was there a piece of paper covering your microphone? There was something muffling you in the beginning.
Do you know, let me, what was that caused the muffling?
So it was where we were using the mic.
Come on up. Come on, sorry. This is Jen. So.
Jen, how are you?
Good. Hi. So we actually have a portable camera, like a small one here in front of Stephanie, and I'm controlling the computer elsewhere. So initially we had the speaker coming from my computer and not her camera. So we just had to switch where the speaker was because there's a speaker with this camera in front as well.
Yeah, so. Once you switched it, it was like night and day. Like, boom, yeah. Good stuff. And I give that juror credit for bringing, hey, I'm having a hard time hearing you. I thought that was, it was good. I was a little concerned, but I'm thinking, okay, let's see where it goes. I don't know how that played out, Mark, and what you hear?
Oh, yeah, I'm glad you switched mics because I had a hard time hearing.
Yeah, right. How about I'm trying to think what else was going on with anything, Greg, or anyone up here? It was interesting. the breakout rooms. How did that look? Were you watching it on the YouTube channel, the breakout rooms?
I watched on the YouTube channel. And I don't think it's any, less boring, for want of a better word, than when you all leave the courtroom and go back to the judge's chambers. I saw several of them get up and, leave the screen and come back with a drink or something like that. And, we might, give a protocol of, ladies and gentlemen, we're going to go in the sidebar. This will take about, I anticipate it'll take about 5 minutes. Feel free to refresh yourself if you wish to do so. Go ahead.
No, you're right. I mean, that's exactly, the whole time I'm sitting here and we're doing the jury, the witness and all that. I violated one of Steve's rules, is let the jurors ask questions. We didn't let the jurors ask questions of the witness. I was thinking, oh man, he's going to kill me.
Yeah, that is one thing that we should have modeled, but I guess I thought that, the in-camera sidebar and the objection and the juror question coming out was probably enough modeling. But yes, you're exactly right. We'll want to keep all the innovations that the Civil Jury Project is advocating, including juror questions. That after the witness is done, the court asks, do you have any questions? We'll have to figure out the protocol for submitting them. Whether they can do it through chat or whether we can't have them ask it out loud. Right. I just think
we have the chat capability. They could chat, and I could then call the lawyers to a sidebar, and then we could ask this. There's 2 questions on this witness. Any objections? And then ask. And of course, you live through it, and then you're like, oh, why didn't I think about this in the rehearsal? Just stupid things like that. I was like, oh, And then what if the witness comes early? We have to have a witness room for the witnesses to hold them in there so we can accept them and put them in the witness room rather than let them lingering, like trying to figure out what happened. I mean, just little kinks that for the first one, that we're doing like this, it's not a bad, that's a bad thoughts on it.
Yeah, I thought it worked well.
Yeah. I like jury selection. I thought jury selection was interesting. I was trying to think of a way, because obviously Stephanie brought up the fact that you got to be able to see people's hands go up, and the jurors are constantly shifting around on the screen. So I tried to think of a way to move through it fast by getting the information I needed. And I thought it worked okay. I was actually pleasantly surprised. I mean, once the panel starts getting a little bit bigger, it just becomes harder, but it went well.
Yeah, it's interesting. My wife, Carol, does communications consulting for NITA, and her phrase is to speak to the camera, listen to the screen, talk to the camera, listen to the screen. But on jury selection, it's hard because you want to look straight on at the camera like I am, so you have eye contact with the jurors. But then once they start talking, then you want to look down and see how they're responding, how the other jurors are looking, if the other jurors have any reaction. And it's also disconcerting because we cannot arrange the tiles in this platform. It would be great if we could all be on the same tile, because then that would explain why, Eric, you're looking down like this at juror number 6, but Stephanie may be looking down like this at juror number 6, simply because of the way her tiles are arranged.
Yeah, I think that will be the software companies, if they can create a trial courtroom where there's a jury box, the 6 jurors in the jury box, or 12 jurors in the jury box, and the plaintiff and the trial counsel and the judge there. I think that would be so much. I think that'd be a great aspect of Zoom or whatever platform we use.
Yeah, there are 5 or 6 platforms that courts are adopting, and a lot of them are all different. They usually have the same features, but I've not found one where you can click and drag the boxes around and arrange them how you wish.
Do you guys, any tech guys, know anything? Do you guys, anyone over in your office have any ideas on that, or you guys looked at it?
Not yet. I mean, we've just looked at the platforms that exist, and I think they all have, like, you know, Mark said, they all have similar issues with that regard. So there really does need to be a litigation, I think, specific type of software.
Yeah, interesting. But I love the idea of putting a juror up, the big red juror, and playing it. I just thought that was, how that was put on was tremendous. Who did that, by the way?
That was Eric.
Well, putting the juror tile.
Yeah.
Yeah, that was me.
I thought that was great. It really, one of our jurors, you were great. One of our jurors' computer froze, and juror 3's computer froze, and she ended up getting another computer, I think, or doing something, because she lost her juror panel above her head. And after we excused the jurors, I'm like, oh my God, we've excused too many jurors. We got to get one of them back.
Yeah.
She lost her jury panel. You know, it's so funny. I'm like, of course, thinking, okay, did I excuse too many? Oh no, wait.
I don't think she ever got it to work. She did not get it to work.
Oh, really? Okay.
In the beginning, yeah, I never saw it behind her.
Okay, interesting. So yeah, but that was, I mean, that was perfect. She froze and then came back in. That was a hiccup. I was like, uh-oh, well, how we're gonna respond to that, you know? And then hypothetically, what if she couldn't get back on? I mean, is that like a juror going on a break, never coming back, and do we just move on? And
I think you're going to have to definitely have alternates in these cases.
Yeah, I think we probably, in a real trial, I would probably have 2 or 3 other alternates just as backups to be on the panel in case somebody's computer malfunctions or something. Absolutely. Yeah. Yeah.
As part of this, also the requirements, when we're talking about this debriefing, about the requirements that court should have.
Yeah, speak up. Greg Popovich, our court administrator, is here. Greg, come on, step in. He was the bailiff opening the court, Judge. So he was. I said, Greg, do you remember doing that? So Greg, come on up here so we can see you. Hang on. He's got some ideas.
Well, they're just. You get out.
Here he is. This is Greg Popovich right here.
Hey, Greg.
Certainly, as I watch this, at least for recommendations for our colleagues, we will be watching this and/or be calling and asking questions. Certainly, the larger the monitor, the better. There's no doubt on this end of things. Definitely need to. I don't see any way around that. But also, just in case, we're probably going to need a third monitor for the public, so that no one could ever say we denied access or public access to the courtroom, because these monitors are so close to the bench. There's absolutely no way that if someone were sitting in the courtroom, it could actually see the proceeding. So really, 3 monitors, I think, are minimum for doing this. So that's just something for us to, in the future.
So one facing out.
Facing out.
We got the dual monitors here, and then the third for the public.
So just in case. I mean, I know we have the YouTube thing, but still, from a public access standpoint, if someone were to sit in the courtroom, they have every right to be able to watch it.
Yeah, there is, there's going to be discussions as to what it means to have a public hearing. There are certain, before the pandemic, certain impediments to, watching a court hearing. You had to drive to the courthouse. You had to go through a metal detector. You had to sit in a room that perhaps had a limited capacity. Is making it public, meaning we're going to be willing to stream it to the entire world? I've heard some, various thoughts on this, and one is that you have it public, you do stream it, but you have people register and have a limited amount, just like we have a limited amount in the court system. It'll be interesting to see how courts address the public's right to view and the access, and whether it's going to be totally unlimited or not.
And of course, you have the separation of witness issues,
Right.
circumstances. And those are things we're discussing here. So we can beam the image to another room in the courthouse so that the separation of witness wouldn't be an issue. I mean, those are all the questions as we move forward that I'm sure people are going to have.
Let's take it over under, Mark. Who do you think won?
This is a tight one.
They try to make the NEDA problems as even-handed as possible. So we try to call it close, but although the volunteered statement of Walter Watkins saying I bought a cut rate, that kind of snuck in there.
Yeah.
And I realize that there might be objections and might be sustained or overruled. In analyzing this case, I think the issue is whether you ride all the elements in, which is what good defense attorneys do, or whether you concentrate on the one element of knowingly, because, you know, poor Dan Jones is the butcher, the baker, and the candlestick maker there at Cut Rate. He's got to, you know, mop the floors, stock, you know, do 101 things since he was the Lone Ranger that night. It's always an interesting case, well tried on both sides. And I think it shows that energy translates through the computer screen. And I also think it shows that even for the small cases, the visuals keep people's attention. I cannot imagine attorneys just doing all of this verbally without backing it up with something that the jurors can see.
Yeah, I'm very interested in seeing how this jury comes up, and it's going to be interesting to see what Mike has, his impressions. Did you, with the dual monitors, I just thought it was just fun to watch all the other jurors' expressions on my one big screen as the one witness is talking. It was just great having the dual monitors. So your witnesses testify, both sides witnesses are testifying. I'm looking at all the jurors and their reactions to the witnesses' comments. It was interesting.
Yeah, and I've got to thank Mitch Chester. He's probably watching right now down in Florida because he's the one who alerted
Hi all.
to this.
Sorry to interrupt.
No.
A verdict has been reached.
Great. Well, good luck. I will remind the parties, please do not overreact. Don't go shouting and throwing your computer screens anywhere. All right.
Mr. Jones?
Judge.
Yes.
Judge Sheehan, how are you getting the verdict? Am I telling you now? Or?
I'm gonna ask the jury if they reached a verdict,
okay,
and have the foreman read it out loud to us. All right.
Sounds good.
Good luck, guys.
Good luck, Stephanie.
Thank you. Same to you.
All right, we got one more juror coming in. Hang on. Jurors, welcome back. My bailiff, virtual bailiff, Michael Pressman, has notified me that you've reached a verdict. Is that correct?
Yes.
The jury foreman is juror number one.
Yes.
Juror number one, I'm going to ask you, would you like to please announce your verdict publicly, how the jury finds?
The jury finds votes in favor of the plaintiff.
Votes in favor of the plaintiff. And I'm going to ask each juror, is that accurate? And is that your decision? I'm going to start with juror number one. Is that your verdict?
Yes.
Juror number two, is that your verdict?
Yes, Your Honor.
Juror number three, is that your verdict?
Yes, Your Honor.
Thank you. Juror number four, is that your verdict?
Yes.
Thank you. Juror number I'm looking before I say it. 6. Is that your verdict?
Yes, Your Honor.
Juror number 8, is that your verdict?
Yes, Your Honor.
All right. I believe I polled all 8 members of the jury. Any questions by, or anything by plaintiff or defendant at this time?
No, Your Honor.
I think we'd both like to thank the jurors from our perspective as well for serving this afternoon, and hope you all enjoyed it.
Ladies and gentlemen, I do want to thank you on behalf of the court, the party, the Civil Jury Project, all members out there in YouTube land who are watching this trial. I want to thank you for your service. If you don't mind, I'm going to excuse you now from your jury service and allow you now to talk about this case with anyone you wish to, but specifically us, because we would love to hear your responses and to think how this all worked out. And I'm going to turn it over to Judge Drummond to lead the discussion. Judge.
Okay, thank you. Well, I'll start with juror number 1. We're interested in what you liked, what you did not like, and areas for improvement. And I'd like the attorneys to jump in at any time with supplemental questions. So juror number 1, your actual name is Alexandra, correct?
Correct.
Alexandra, what did you think?
Well, I thought this was great. Thank you so much for allowing me to participate in this. So I think a lot of more constructive feedback is logistical. So as a juror, I would have appreciated more kind of instruction, like, you know, an idea of how long I should be expected to be sitting, when breaks were expected, what I should have on hand, like water, paper, pen. And then also, I may have missed this part in the emails, but like an instruction about my background, because I don't know if you've noticed, my background has improved since the beginning of this. Something specific about the Zoom. So when I was in like full screen mode, I could see the videos of people on my right. And then so when someone was presenting, some slides, some of it was blocked by the videos on the side. And so I don't know how that would be fixed with like all different kinds of screens and devices, but that's just something to keep in mind.
I'm going to write a note. There is now I am echoing.
I think you got to mute juror. I'll mute her. There you go. Sorry, juror, when I muted you. Go ahead, Mark.
There is up at the top of the screen on Zoom, it has view and it has side by side, and it separates those out for you. So that's an instruction that we should give to the jurors, and I will include that in the protocols. Okay, Alexandra, anything else?
That's all that I wrote down. Thank you.
Okay, Anita, word to you. What are your thoughts?
I thought the presentations by Eric and Stephanie were excellent. I knew we would have good lawyers doing this. It's a different way of communicating, and both of you were able to, at least for me, reach out to me, and I felt like you were talking to me. I loved when Stephanie took Eric's walks like a duck, flipped it around. Kudos to you, Stephanie, on that. And then sadly, you two agreed that there was no rebuttal. So I was kind of waiting to see where it was going to go. So substantively, I thought it went very well. Let me just talk about some of the technical things with this, and then what I saw with how witnesses are displayed. And by way of background, I'm a lawyer and I represent large companies. So I was thrilled to be on this jury to understand kind of the psyche of it all.
Well, I was thrilled when you logged in. I didn't know we were going to have you as a juror.
I'm so glad. So, all right. So what I've noticed, we worry about this all the time. When you represent large companies, a lot of jurors don't like us. I'm just saying. Quality of video is very important. So what I noticed with investigator Beer, and we talked about it as a group, his video looked terrible. Let me just tell you, he looked terrible. He looked like a bobblehead doll. He was hard to follow. Now, at the same time I say that, he looked terrible and had a bad camera in front of him. We found him to be quite credible. Now, the defendant, we thought was a little too slick, right? He had a little pin. He works in a liquor store called Cutthroat or Cut Liquor. So we did not find him, to be honest, as credible because of that. We didn't. So just watching him. Now, were we able to watch them through video? That's something I know the lawyers want to know. Yeah, I think we were. We were able to watch up here. If he's one of those guys that was like doing his feet really, we wouldn't have seen that. We wouldn't have seen that part. But from up here, he was very smooth. But to me, and everybody, we talked about this at great lengths, because you should know I wanted to find for the defense going in here for a lot of reasons. And the group convinced me, because that's the process, that, if for somebody who worked in a liquor store like that, he would know the signs. You don't need to have a breathalyzer. You don't have to do any of those things to have the signs. As a juror, what I would like, we never got anything that said don't communicate or chat with each other. So I didn't want to break any rules, but I did send a chat to the bailiff at one point saying, can I take a potty break? The other thing I was doing, because we didn't have any rules on it, is I was using my cell phone. I was, kind of checking around about liquor, what's going on in the state of New York with liquor. So that's another instruction you're going to want to have. Do not look at your cell phone. I am quarantined in Nashville, Tennessee with my family. And there was a point of impeachment when Stephanie was doing an impeachment with the document. I don't know what it was, if it was the falling and he pulled himself up, whatever it was, my printer, because my husband was printing something, was going full blast. I couldn't hear it. I don't know how we tell people to do this. I have a cat. My cat was in here. My cat actually muted part of some examination. I couldn't believe it. I was going, oh my God, I'm not hearing everything. So that's another thing I probably would caution people against. I also didn't know when we were taking breaks, if I could just casually chat with other people, right? Not about the law. I know we can't talk about the law, but if we could just say, hey, how are you? Because I got to bond with the group, right? Like in a real jury, we would be there, we'd be, doing virtual hugs, and they were so smart, and I'm going to come away with warm fuzzies. But I do think we need instructions on, you can't chat. Well, frankly, you could watch the chats. You shouldn't do anything on your phone. I think the jurors need to be in a virtual system in a place where they don't have background noise. I would never want to have young people with children on a virtual jury, because they'll never be listening. They'll never be listening. But those are my.
Those are great. Can I make a couple comments? Those are great comments, and I should have been more directive with you about breaks. One of the thoughts I had is, how would you have felt if I allowed you to ask questions? Would that have been helpful? It would have been through the chat feature. It would have said, if you have any questions after the first witness, you would check.
Oh, yeah. We would have loved that. Judge Sheehan, we would have loved that. And then I guess what you would do is you would look at them and say whether or not you want to ask those questions or not. So one thing that was interesting here was what became interesting was the fact that the investigator was responding to a call, right? There were other incidences of alleged selling to intoxicated people. So I knew that probably wasn't going in for the truth of the matter, sir. It probably was just going to establish him. But all of a sudden, our jurors are going, wow, they've got a problem here. They got investigators sitting outside. And I bet, Your Honor, if you had asked that question, you would have gotten all these chats about, follow up on how many times have the police been out there? Like, what's going on with this guy? I kind of liked it, but I don't know if a judge would want to do it.
No, great comment.
We talked about how we certainly couldn't have the jurors orally ask the questions. It would have to be by chat in writing so we could sort out the objections, because you're exactly right. They will have questions like that, and they need to be instructed whether that's relevant or not. So Bailey, we are to you.
Yes, I think I inadvertently had a lot of tech problems today, so I'm happy to talk about that. In the beginning, when we were doing voir dire, my Zoom crashed twice, which has never happened to me before, ever. So, and as soon as other jurors got dismissed, I didn't have any more problems with Zoom. So I don't know for sure, but it may be that if there were so many people on with the video, that could be an issue, just to flag. I did want to say whenever one time it crashed right as I got a question and I got a little panicked. And as soon as I came back, the judge was like, oh, juror number 3 is back. Now we'll redirect to her. And that was like very helpful just because I came back kind of stressed, like, I don't know what to do now. But maybe to that end, if there was just a little bit more instruction, like, you know, if you have a tech problem, if Zoom crashes, if you can't even access the chat box on Zoom, like, here's the procedure of what you should do, because I think that's inevitable. That's going to happen sometimes. Another small technical thing that I found really helpful, part of the way through, the camera in the courtroom zoomed in, and I actually really liked that. I feel like being able to see the judge up close, there's something, I don't know, there's something about it, just being able to see your face makes us feel a little bit more like indebted to you or something, you know, like we trust you a little bit more. So I thought that made like a really huge difference for me for some reason. So it's small, but
it's ironic you say that, because we talked about that. I at first was going to be critical of it being such a long shot, because I thought the judge should be in the frame more. But then I was also concerned about the judge's face filling the frame, because the jurors watch the judge to see what he or she is doing, their reaction to questions, you know, whether they roll their eyes. I mean, we try to be like a sphinx up there so you can't read us. But I agree, when the camera went in closer, he was more involved, but I'm not sure we want as tight a shot as we have on your faces as jurors.
Good comments, yeah. Especially on that duck comment, I did one of these.
So Bailey, anything else?
that was it. Those are my big ones. So
okay.
Thank you.
Thank you. Danny, where do you?
Yeah, well, first of all, thank you guys for having us. It was a really fun experience and really great to see the attorneys in action. I think one response
and I want to say this: you have 2 of the best attorneys. If you Google them, you'll see the cases that they've handled. I am so grateful that they were willing to share their expertise with us. Go ahead. I'm sorry.
Oh no, for sure. It was really amazing to watch. I was trying to think about, you know, things related to being on Zoom, and a couple of thoughts with the jury selection. It seems like on the one hand, maybe it's more likely that I would be willing to admit to something embarrassing over video than in person. But on the flip side, if there was something that, if I really wanted to be on the jury and there was something that I wanted to hide, I feel like it would be easier to kind of let that slide. So I don't know, the first question about, do I have any negative feelings towards police officers? My grandfather, who I was portraying, has very positive feelings towards police officers, which came out later. But I was thinking in person, maybe he would have made, I don't know, even right then kind of said something about it. I also, when I'm in person in a courtroom, I find it to be like completely compelling. And not that this wasn't compelling, but I felt my focus drifting more than it would have been in person. And just from having a couple months of Zoom classes, I know that is just kind of a probably inescapable part of being on video. And I think that strategic uses of breaks in a different way for video run trials is really important.
And what do you mean breaks in a different way?
I guess, I mean, I don't know what typically goes into a decision for when to take a break, but I think probably more frequent breaks and maybe, you know, pre-scheduled or something like that. Yeah.
So that you know when the breaks are coming.
Yeah, I think so. And on some regular basis, I get the sense that I would need more breaks for focus reasons, being at home than I would being in an actual courtroom.
Okay, fair enough. Thank you. Hope.
Hi, yes. First off, I want to echo what's been said. Thank you so much. This was so much fun to be a part of. I think the first thing I would say is I thought also that the attorneys just did a fabulous job. I thought the exhibits in particular were extremely helpful and extremely clear. On the sort of technical aspects, I was thinking about the first thing is kind of just more a thought, but I noticed that in the voir dire process, it seemed to me, I know that we're all, we've self-selected, we're a group who's volunteered to be on a jury here, but it felt to me like we were all trying to a certain extent, get on the jury. People wanted to participate. And I wonder if, as opposed to, normally I think people are trying to get out of jury duty. So I'm wondering just if the Zoom process is, even if we had not volunteered, would change the jury dynamic because people are more comfortable doing it from home. And, it's easier for people to participate, if that might change, I don't know, people's answers during voir dire at all.
Well, it's interesting you say that because we were talking about how to attract jurors to this platform. And there's a thought that the juror summons goes out and gives them an option. You have the option of appearing at the courthouse for an in-person jury trial, or if you wish, you can do it virtually. Now, that might involve some self-selection where you wouldn't get a good demographic, but we know there are people who would prefer to do it this way, and others who may not or cannot. But yes, these are all hurdles that we're going to have to be talking about. And I'm sorry to interrupt you, but please go ahead.
Thank you. Yeah, no. The other thing I would say is that I thought the labels, the defense attorney and plaintiff attorney label in particular, were extremely helpful. One other thing I noticed was when I think it was a witness joined the meeting, their email address came up, which I think, as opposed to a name or like a pre-identified tag, which I think is just something to be aware of because it may provide more information than you want to give out
Sure.
necessarily. And then the last thing I was thinking about is, I guess this may differ based on the rules of the courtroom, but that I thought it was interesting that the defendant wasn't present the whole time. And I think in a normal jury, oftentimes you're looking at the defendant's reaction to different statements that are made. And so I wonder if that was on purpose or what the choice was there.
And that's an interesting observation because one of the protocols we're dealing with is what can the witness see when the witness is being examined? Now, in a real courtroom, the witness can see not only the attorney who's cross-examining him, but his own attorney. We have the ability now to just have the witness see only the attorney who's asking the questions, which eliminates, signaling by counsel as to, sometimes it happens. A lot of the times we find that the protocols we're writing that, 80% of them are to cover 20% of the problems. So we could virtually eliminate witness coaching by just what the witness sees during the questioning. But you're right, especially in the criminal realm, the witness has the accused has the right to confront the witnesses against them, and the defendant must be present at all times. So you would have liked to have seen Dan Jones in the frame to see what he was doing.
Yeah, I think it would have been interesting just for more credibility determinations.
Okay. All right. Okay, then Jill, bring us home.
Sure. So first of all, echoing everyone again, thank you guys so much. I really, really enjoyed this experience. I've never sat on a jury before and have always wanted to, which I know is not the norm, but being in law school. And I really, really enjoyed this and found it very captivating. The two main takeaways that I felt and experienced from this process. First, I think it would be very helpful for all potential jurors to receive some kind of email for those that do sign up for the virtual jury and not the in-person jury, kind of laying out what is expected of jurors if they do end up being selected. So, and I think that would kind of help some of the problems that Rachel brought up of background noise, child's care, pet care, etc. Not everyone that is going through the jury selection process has been a juror before, and even if they have, it might have been many, many years ago, or they just might not take it so seriously, etc. So I think having a clear framework sent out in advance would be helpful. It would also allow for a realistic assessment of whether someone could or could not participate as a juror. Do they have 3 small children, and is it just totally untenable, or is it something that they can manage and arrange in advance? So that was the first thing that comes to mind. And that goes, the second piece of that is about distractions on the internet. So, you're on Zoom, you're connected to the internet, your emails are still popping up, even if you put your computer on do not disturb or silence, you still might see it, or you might be tempted to look. So I just think that it would be really helpful if the judge in the beginnings explained how important it is to be focused, to stay offline other than this Zoom call, just to, kind of warn people that they really need to be paying attention. This is really important. And then the second comment is more of a positive comment, which is that I just found the slides that were shown to be really helpful in keeping me focused. It's captivating, it's visually interesting, and it also just, it made me feel more part of the case, I guess.
Okay, thank you. I want to flip it over to counsel. Stephanie, any inquiry?
I do have a couple of questions. And again, it was very interesting for us also to go through this process and to hear your comments. So for a trial that's in person, one of the things that I think the lawyers pay attention to with the jurors is how they bond among themselves. So for example, if you have a jury of 6 and from jury selection, you feel like maybe I'll just say jurors 1 and 2 seem to have a leaning toward your side of the case. And maybe during the trial, you can watch them and maybe from their body language, you think the same. So for a trial in person, there's bonding that goes on, who you're having lunch with, who you go out and talk to in the hall during a break, and who walks in the door together, that kind of thing. You don't have that here, obviously. Was that, I'd like to hear your reaction to a comparison of the relationship you all had in your deliberations virtually compared to what I'm describing in person.
I can answer that, I guess. I've never been on a jury in person, so I wish I had been, but I don't have that direct experience. But when we went into the jury room, I think because we hadn't had any experience to speak to each other in any context previously, no one wanted to speak up at first, which wasn't a problem, but I imagine that it's very different than a jury room would feel like, after the end of a trial when you've actually spent time together in person. So I don't know how that changed the result or the process at all, but it was notable.
Was it easy or difficult to select the 4-person?
Rachel helped us. I mean, it ended up being easy, but I think because we don't know each other, I don't know the other jurors, and we never even spoken to each other. There was nothing to go off of except for someone to just, volunteer, basically.
Well, I was also trying to be in the character being my aunt who would have never stepped forward, but I would have. So I don't know. I just ended up doing it. I think someone would step forward. I think it was just, an interesting simulation.
So Stephanie, I think that's a good thought. You're right. We didn't have a lot of bonding, and you see that with jurors. Where I saw the bonding was during when we were being asked questions. I saw people and I saw their responses, and they go, "Oh yeah, I feel like that too," right? So that was part of it. But then once we got in the jury box and we picked our 4-person, really because she volunteered, nobody else volunteered. I felt warm and fuzzies with you guys. Did you not feel that? Yeah. I mean, I thought we were trying to, it wasn't a situation where how some juries will hate each other, there'll be a juror who smokes and everybody hates that person. We didn't have that here. And everybody was really open to listening to other people. So I thought that was a plus.
Anita, I'm sorry, when you say you saw their responses, were you using the chat back and forth between the jurors?
No, I wanted to, but I didn't think that was probably appropriate.
Sorry, Stephanie, I just had to clarify.
Yeah, no, I wanted to do that. Like, I wanted to kind of chat with them. Like, I knew that Mr. Williams, juror number 6, was it? Or, you know, there was one who kept saying, I hate the police and this. And I was going, oh, he's going to be bounced for cause, right? We were all kind of waiting for him to go. You kind of waited there, Eric. But, you know, so I was watching what they were doing. And yeah, if I was allowed to chat with them, I would have sent them little chats if it was appropriate.
We'll have to make sure we don't allow that.
Don't allow the chats, you're right.
Okay,
Although,
Stephanie, I'm sorry, go ahead.
there'd be a written record of what they're thinking about to be analyzed.
Stephanie,
So,
any other questions?
Yeah, I had a quick question because juror number 4 had mentioned, I guess, so when you guys were like if we had a break and you guys were during the middle of trial, you guys weren't all in the same room with each other? You guys were just locked into your own room? Is that what happened?
During the breaks, I think we all were in the main room still. Or do you mean when you were on a sidebar with the judge? Or during
I'm just trying to think if we took a break at one point. No, maybe not. I thought that the jurors were put back in I guess, yeah, maybe during sidebar. Could you guys still see each other during sidebar?
We could, but I guess it seemed, you know, because we were still in the courtroom, nobody was talking. It was just kind of, you know, we were all sitting silently in the.
I got it.
That was interesting analysis there, Eric, because when we do a break, that's maybe to keep that bonding part. We, instead of just mute your computers, go put the jurors in the jury box in their jury room. And if you guys want to talk or bond with each other, you can. And when we're ready to come back, we zoom everyone in, because in a normal trial, there'd be motion hearings or arguments or something on an evidence. We'd keep you in the jury room. And while you're in your room over there, they could bond and talk to each other.
Yeah, they have to be in the room, because if they're left in the courtroom, then the public could listen to them bonding. They could listen to anything they're saying. So yeah, they should probably go into the jury room.
Yeah, and that was, I have to tell you, that break, when we mapped this out, we didn't think we needed we didn't even think about a break. And I was dying up here. I go, I gotta go to the restroom really bad. I'm looking at some of you, and I didn't get notice from you, Rachel, that you needed to use the restroom. I'm like, okay, I've gotta go. And I'm like, all right, we're gonna wait till after that witness before closing on this. So that's funny.
All right, anything else from anyone else?
No, I thought it was interesting from my perspective, watching your faces. I was watching everybody's face, and it was interesting to me to see your reaction to some of the testimony, to see your facial, you know, I knew, Rachel, I knew you were doing something. I thought you were taking notes. And I didn't give an instruction on notes because I figured, well, let's see what they do. But I was wondering either you were texting something. You were taking notes, yeah. So I saw you writing, and one other juror, I think, was, I don't know if you were texting. I don't know if I could tell. You're looking down, so I'm assuming you're reading your phone or looking at something. But I was able to observe it. Didn't say anything. I was just thinking, okay, let's see, maybe see what happens. What did you think about the breakout room when we brought the juror to sidebar? Were you worried about that? How did that make you guys feel? Were you kind of like, whatever? It's a normal court case, right? Anyone have a thought on that or no?
Well, so we had the breaks, and really, I just didn't know what to do during the breaks. This is when I started looking at my phone, kind of looking if I could use the chat function, started chatting with the bailiff. So you're right. I think it's a good point to think about what to do when they're just kind of stuck. But Judge Sheehan, I like your idea of putting, when there's a sidebar like that, putting them into their deliberation room so that they can sit and talk about other things. Like,
yeah, right.
You know, where are you at or whatever. I think that's great.
Yeah, it builds that camaraderie within the jury.
Yeah.
We didn't think about it. Right. Good. This is great for me. I love this.
All right. Well, if there's nothing else for the good of the cause, we will thank you. You've given us a lot of information. This has all been recorded. So what we're going to do is we're going to probably do some editing, add some, subtitles as to what went on, what should go on. And we should be posting this on the Civil Jury Project website within the next couple of months. But you have given us a lot of material to work with, and we thank you so much. Thank you, counsel, for your time and your energy into this. Thank you all for being jurors. Judge Sheehan, you and your team have been fantastic in Ohio. Michael, thank you for being the bailiff. Alex, thanks for looking at the camera. You modeled exactly what witnesses should do.
And great job to everyone, the lawyers, great work. And Mark, thank you for organizing too.
Oh, my pleasure. Thank you so much. Have a great weekend, everyone.
Thank you, Mark. Thank you,
All
Judge.
right.
Thank you, everyone. Really great.